one matter orally. Your Lordship, it's really very urgent. It is an SLP against the cancellation of an anticipatory bail. And Your Lordship, as you're already aware, there is this vacation next week. Please, I request you to allow it to be listed for tomorrow.
We have filed it today only.
I think my brother has given very good suggestion. In mentioning itself, we will hear the matter and dismiss.
That's the only.
That's cancellation of bail. Bail has been cancelled. Go and file.
It was an anticipatory bail that has been dismissed.
Your directions are complied with. It will be listed tomorrow.
Much obliged, Your Lordship.
Lord, may I mention?
My lord, item 4, my lord, is a regular matter. Mentioning is not allowed. I have already tried it. In fact,
A regular matter we will not entertain, also not mention. Tomorrow there is no question of any regular matter.
my lord,
Miscellaneous day.
my lords, these are teachers whose pension is pending, my lords.
In opening, then I will decide. I will to take a call whether I will treat it a miscellaneous week or it will be usual week, depending upon the total filing. If the filing is large, then entire week will be miscellaneous. Then there is no question of regular matter in that week also. Then it goes second or third week of March. Then you can make amendment.
Obliged.
My lord, in item 55, my lord, the suo motu, my lord, at the outset, my lord, we tender an unconditional and unqualified apology. The Secretary School Education is here. My lord, we have published the apology.
But saying, Mr. Solicitor General, in this notice I have received in the morning,
Yes.
Our friends in media,
Yes.
those who have been very closely watching what
Yes,
is
yes.
happening in NCERT, they have single word of apology in this notice. also.
Inadvertence is what they say.
Only a minute,
Not a
sir.
single word of-
Don't mind.
It is definitely deliberate, definitely deliberate.
Not a single word of
It
apology in
would
this
be-
notice also, and the manner in which this director has attempted to compound. When simply I asked the Secretary General only to verify whether such a publication has taken place or not. It was our institutional duty to find out, because we didn't want to say that only that on the basis of a newspaper item. So a very responsible newspaper had published it. Still, I asked the Secretary General to find out whether such a book has
Veracity of
published.
this.
In communication, he is defending.
Defending and justifying, my lord, I have.
Fine.
My lord, there is no justification, my lord. We tender an apology. This would
That's
be,
not the deep-rooted conspiracy.
my lord,
Absolutely, 100%.
quite possible
To damage
my lord,
the
I am
institution.
Also, my lord, informing your lordships that the two individuals who prepared this, my lord, chapter, my lord, will never be associated with any activity of this ministry, or my lord, I'll try and see any other ministry. My lord, there appears to be, my lord,
That may be very light action. The way if they are allowed to go scot-free like this, then it's a very, very light
my
action.
lord, whatever your lordship,
Something, you see, they have fired the gunshot, the judiciary is bleeding today.
absolutely.
Yesterday, the kind of message I am receiving from the
Lord, all of
moral
us
of
are
the
holding our
judiciary is down.
head in shame.
And today, you simply, somebody will say, I tender unconditional apology because it's an
No, and yesterday, Lord, I saw a podcast. Some former director of NCERT is justifying this openly, and his video is circulating everywhere, justifying.
My lord,
This is the kind
this
of-
would be, my lord, republished. I will, my lord, vet it. And, my lord, whatever, my lord, your lordship desires, shall be done, my lord, for those two individuals.
This communication, I read it minutely because still while sitting here, we don't carry kind of any. It is not that we will be emotionally swayed or anything. We have to perform our duty. Sometimes we perform in very hard times also. And when there is a mounting attack on us, we know even how to maintain objectivity during that time also. Now they say publication will be withdrawn. It is in public domain. It is available in different social media sites. It is available. People go and buy it in market. Yesterday, the senior counsel was showing to me. I also got a copy from somewhere from this.
My lord, there are 32 books which left, my lord, which went in the market, which are being withdrawn. The rest of the books we are not circulating. The entire chapter would be revisited by a new team. My lord, not only, my lord, the offending part which your lordship found offending, there is another part where, my lord, there is a pendency figures given, where the title is justice delayed is justice denied. We can't teach our class 8 students that justice is being denied in the country.
Mr. Solicitor General, it is not the class students. It's a very, very calculated move. How the class students will do?
Lord, I am not defending even that.
First you will read. The entire teaching community will be told. Only then they will teach the students, 8th class. So when you teach the entire teaching community is first told that look here, Indian judiciary is corrupt. There is a lot of penancy in Indian judiciary. They are
And therefore justice is denied.
So first teachers will, because a teacher has to do his own homework before teaching. So first entire teaching community has been told. Then what happened in school? What is the reality? Reality is that parents are also, because the parents will study. So there is not a single part of the society has been left. It is such a deep-rooted, well-planned, orchestrated.
I would not
Holistic,
deny
no,
or
holistic
dispute.
approach. Only one sector is selected. Well, it's nothing about anything in the over endemic system.
Yes, yes, my lord.
One person is selected.
My lord, the judiciary, the bar, the business community,
Bureaucracy,
the extortion.
political.
What about the politicians, the bureaucracy, the ministers,
The politicians,
ministers? What about them?
Lordship, they have already done what they want to do.
And Malad, this is in PDF form. Malad, it says in
Lord, I
the
am
book.
not defending
But
it.
this is in
Lord,
PDF
the
form
government
circulated
has-
throughout.
Lord,
What do
there
you
is
do
no
about the
point in
PDF
not
form?
scoring points. I have, Lord, the government has taken.
National, my lord.
Leave it.
Some of these articles, or at least excerpts of the book, are in the digital domain.
Yes, PDF.
We take steps on behalf of the government to issue to these platforms takedown orders.
Yes.
We shall do that. I'll speak
Takedown
to the
orders in
secretary.
respect of the excerpts which appear to be
Circulating mass.
extremely lopsided without emphasizing on the performance of judiciary as the protector of the constitution.
Yes.
That has not been done. Judiciary is the protector of constitution,
I
the legal aid and the access to justice, judiciary through
Lord,
judgments and exercises.
I'm grateful, my lord.
They have not been highlighted at all.
I undertake, I'll speak to the secretary mines. Lord, we have statutory powers to pass takedown orders,
Whatever
must be taken down, my lord. Yes, my lord, I bow down.
It's all on the website,
That's
PDF form.
Meeting has the statutory
the
backing.
state will take
Yes,
that
yes,
responsibility.
I hope so. I hope so.
Directions to upon the
Yes,
To take down.
take down. That's very
Takedown
important.
orders can be passed. There are statutory provisions
Yes,
and
yes.
statutory provisions will be exercised.
Actually, the circulation there is much more than the hard copy.
Of course, always.
Connection with that.
Always.
32.
Everybody has it, but people are sending it around now.
Lords, with the utmost
Lordship, in this
respect,
case,
the
the
damage
claim
has
will be
already been
identified.
done.
I
There
would
should
now
be some,
that we are not
some
accepting an acknowledgement,
accountability.
we are not rejecting, but we would like to have a deeper probe. Our first, as a head of the judiciary, it's my duty to find out who is the person responsible. If there are more than one, heads must roll. Accountability must be there. I am not going to close this proceeding till I am satisfied as an institutional.
We will
Well,
fully
then the
assist
board
your
can-
lordship without,
Members of the board confirm it. There are X number of members of the board who have confirmed this. It goes to the board.
Who are the person behind it? We would like to know it.
your lordship, my lord, will place everything on record, my lord. We are not taking adversarial stand. Lord, we stand by the institution and my lord, whoever is responsible must pay for what they have done to your lordship's satisfaction.
Whatever the level of betting, man, it should not be allowed to go scot free. They should not be allowed to get away with this.
Leave it.
Whatever the level of betting. It is the well calculated move, Lordship.
Right. The framers of our constitution were profoundly conscious and took abundant caution to ensure that the constitutional functional responsibilities were inscribed with such precision that the three pillars, namely legislature, executive and judiciary, remain capable of operating with their respective autonomy while functioning in concert to preserve the democratic fabric of our nation. While acknowledging constitutionally described demarcation, we were nearly shocked when one of the leading newspaper published an article regarding release of the social science textbook for grade 8 in bracket part 2 titled inverted commas exploring society, India and beyond, first edition, published in February 2026 by National Council of Education Research and Training, that is NCERT. Chapter 4 of the publication is titled inverted commas the role of the judiciary in our society. It incorporates a subtopic explicitly expounding inverted commas corruption in the judiciary. The inclusion of the subject matter within a foundational curriculum in our considered opinion, warrants a rigorous review of its pedagogical suitability and its potential impact on the institutional standing of the judiciary as a whole. We are reluctant to reproduce the contents of the chapter, but it very prominently refers to the hundreds of complaints received against judiciary, clearly indicating as if no action was taken, picking a few words from the statement of the former chiefs of India, to suggest completely out of context. Only to suggest that idea is that CGI himself has acknowledged there is a corruption. This is what they want to do.
Something in further.
Suggesting that the judiciary itself has acknowledged the lack of transparency, accountability for institutional corruption. Not only this, the article further goes on to declare that, inverted commas, people do experience corruption of various levels of the judiciary. That's inverted commas close. In the wake of the publication of the book and a self-critiquing article in Indian Express, that's the newspaper, on 24th February 2026, the Secretary General of this court was asked to verify whether such a publication has been released by NCERT. Instead of revisiting, instead of having an introspection of what had been written in the book in a most reckless, irresponsible, contemptuous and motivated manner, the director responded in writing defending the contents of the book. Next paragraph. On a prima facie, examination of the book's contents, when read in conjunction with the administrative response received from the director, it seems to us that there is a calculated move to undermine the institutional authority and demean the dignity of the judiciary. This would, if allowed to go unchecked, will erode the sanctity of the judicial office in the estimation of the public at large, and more importantly, within the impressionable minds of the youth. While the publication ostensibly dedicates an entire chapter to the role of judiciary to our society, and washes off with one stroke of pen the illustrious history associated with the Supreme Court, the High Courts and District Courts, is conspicuously omitted and without any mention of substantive contributions made by these institutions towards the preservation of democratic fabric. The text unfortunately fails to acknowledge the imperative role of the judiciary, which it undertakes to, in upholding the constitutional morality and the basic structure doctrine, which are the lifeblood of the Indian citizenry's public existence. It seems to us that the narrative contained in the book chooses not to delve into any of the transformative initiatives and measures pioneered by this court towards overhauling even the legal aid mechanism and streamlining the ease of access to justice.
And other things, separate things, and other things.
Absolutely. This silence is particularly egregious given the sheer volume of high-ranking officials who have been censured by this very court in the past for corrupt practices, fraudulent activities, and for illicit sampling of public funds, etc. It seems to us that the choice of words expressions in the book might be, may not be a simplicity or inadvertent or bona fide error. At this juncture, we forget one more paragraph. We may, however, hasten to add that we do not propose to issue these suo motu proceedings, initiate these suo motu proceedings to stifle any legitimate critic or to bring to task any individual or organization exercising the right to scrutinize public institutions, including the judiciary. Contrarily, we are of the firm conviction that dissent, deliberation, and rigorous discourse constitute the very vitality of a living democracy and serve as essential instruments of institutional accountability. Next paragraph. The necessity for judicial intervention, nevertheless, has arisen not from a desire to suppress criticism, but from the imperative to safeguard the pedagogical integrity of the national curriculum. Young students in their formative years are only beginning to navigate the nuances of public life and the constitutional architecture that sustains it. It is fundamentally improper to expose them to a biased narrative that may engender permanent misconceptions at an age at this tender age. For the purpose of appreciating the manifold and onerous responsibilities that are discharged by judiciary on day-to-day basis. While taking this initiative, we have to keep in mind that the subject order is not confined, will not remain confined to the subject book. The subject book will not remain confined to the students only. It is bound to travel. The contents are bound to travel from teacher to pupil and to the parents, namely the entire society.
The next generation. Maybe the next generation.
Generation, including the next generation. Next paragraph. Given the serious consequences and an everlasting adverse impact on the independence and autonomy of judiciary from such a misconduct would fall within the definition of criminal contempt under section 2 in bracket C of the Contempt of Courts Act 1971 as if proved to be a deliberate move, it will undoubtedly amount to impeding the dignity of the institution and interfering with the administration of justice.
Bringing in disrepute, and bringing the institution in disrepute. That's the expression used in the act.
My lord, it also scandalizes the institution, my lord.
Yes, sir.
besides scandalizing the institution. Next paragraph. We may at this stage also take notice of certain subsequent events. The notice has been published, which is reported in media and has also been, and a copy whereof has also been placed on record by learned sources of India, which is a press release issued by the NCERT. According to this press release, the Department of School Education and Literacy, in bracket Ministry of Education, has directed that the distribution of this book may be kept on strict hold until further orders. And those directions have since been complied with. It is further stated that the chapter in the subject book shall be rewritten in consultation with appropriate authority. Next paragraph. An apology has also been tendered through this press release. While the question of considering the question as to whether the apology has been tendered genuinely in order to cause the prima facie contempt, or it's merely a ruse to wriggle out of the consequences, from especially when a substantial irreversible damage has already been done, are the questions we will consider at an appropriate stage. Next paragraph. As of now, we deem it appropriate to issue show cause notice to the Secretary, Department of School Education and Literacy, in bracket Ministry of Education, Government of India, and 2I, Dr.
Dr. Dinesh Prasad Saklani, if your lordships are
Dr.
NCERT chairman.
Dinesh Prasad Saklani, Director NCERT, to show cause as to why suitable action, either under the provisions of the Contempt of Courts Act or in accordance with any other provisions of law, be not initiated against them or those who are found responsible for introducing the offending chapter in this subject. Consider also. One, two. Two, the NCERT, in coordination with the Union and State Education Departments, or any other government or Union of India departments. For my directive to ensure that all copies of the book, from a hard or soft, currently in circulation, whether held in storage, retail outlets, or education institutions, are immediately seized and removed from public access. Next paragraph. Union of India and its agencies will ensure that
In physical and digital form.
immediately in physical and digital platforms
Platforms.
without any delay, and a compliance report by way of an affidavit is placed on the court. Next paragraph. It shall be the personal responsibility of the Director NCERT and the principal of every school where the book has been circulated or reached to A. Effectuate the immediate seizure and sealing of all physical and digital copies of the book within their respective premises and submit a report to the Secretary.
Lord, only one factor, factually, my Lord, I have the Secretary Higher Education. Out of 238 books, please, so that factually there may not be any, only few books have fortunately gone. You can.
These have gone, again, probably he is not being correctly informed. The books have gone in hundreds, may not be in thousands, but in hundreds books have gone.
Then let me check. Let me check.
Within their respective premises and submit a compliance report. We ensure that no further pedagogical instruction is imparted based on the contents of the physical or digital copy of the subject book. Next, the principal secretaries of departments of education across all states and union territories are directed to comply with these directions. The directions given herein above, and send their compliance reports through affidavits within 2 weeks. As an abundant precaution, a blanket, a complete blanket ban is hereby imposed on any further publication, reprinting, or digital dissemination of the book titled inverted commas Exploring Society, India and Beyond. Any attempt to circumvent this order through electronic media or alternative titles containing the same content shall be treated as a direct interference from a willful breach and defiance of the directions issued here and above. Next paragraph. The Director NCERT is further directed to submit a comprehensive list of members of the National Syllabus and Teaching Learning Materials Committee who approve the offending curriculum. B.
Who wrote that article, but that chapter?
So,
It's chapter-wise division.
offending chapter, offending chapter. The specific names and credentials of the textbook development team responsible for drafting chapter number 4 shall be furnished. see the original records of the minutes of all meetings where the offending chapter was deliberated and finalized. Shall be produced. On the next date of hearing. Measure that
Will also consider directing them to place this apology in the public domain, Manoj, because it has now been widely reported, and other newspapers and platforms have also carried it.
why should we advise them?
Yeah, Manoj, I am saying, Manoj, it's my. The fact is that if they are apologetic about the damage they have done, they must on their own place it in the public.
Lord, I have,
Lordship, by advertising, their object will be completed. That is the question. Because they know after the cognizance of the court, it will be removed. And they have done, and it is removed, their object is
I must
completed.
make it clear, this apology, I fully agree, is not an apology. My Lord, we will ensure that an unconditional and unqualified apology is prepared and published.
Grateful. I mean, the solicitor has been very fair. They must do this, Manoj.
Force this matter for.
IT Ministry may be directed to put a gag on the social media because now memes and reels will be circulated.
We have directed, Mr. Sina, we have directed. Because we don't want to depend on it. We have issued.
If your Lordship would like to.
Because the narrative should not be created on this.
These two individuals, my Lord, who prepared this chapter will not be associated with any activity of
That
any
may-
ministry minimum than whatever your Lordship decides.
That may be very light,
Very light, very light.
exit door to
I'm
them.
saying this is the minimum, then whatever your Lordship decides, the government will act accordingly.
We, after the reports are produced, we will seek assistance of one of the some members of the bar. We will request them to go into the record and identify who are the persons responsible. Then,
Lord, Supreme Court Bar Association can be implemented. Lord, we will assist the court in this. I think this is a very serious matter. It affects the integrity of the institution. And we feel very
Yes,
strongly.
I am also not taking any adversarial stand. Lord, I will do whatever is required in furtherance.
this is one issue, whether the office of the Attorney General, Solicitor General or the CBA, SCORA and all the High Court bars. I am getting the hundreds and hundreds calls since last 2 days. The entire country, the people have shown resentment and in a way, in one voice, they wanted me to take immediate action. I also thought that I should not waste. In fact, yesterday when Mr. Sibal and all senior members of the bar, they made a mention. Even before that, I had already taken cognizance and I have passed a detailed administrative order for listing this matter. This is something.
No, we must not be on the same platform, my Lord. All parts of the institution, my Lord, bench and the bar, all should be on the same platform. There is no doubt about it. There is no other view about it.
Lord, one thing more, the media should be restrained from.
It is done. It is done.
That sometimes there are these small panels, so-called, they indulge in irresponsibility. But look at the other aspect. It is all responsible media that has brought it public domain. So we are thankful to the friends in media. They have been very, most of the time, in rare of the rest the situation, they might.
Mainstream media is always, my Lord,
Always,
responsible.
yes, yes.
It is the exploits which creates the problem.
As a one of the pillar of the democratic values, and I think in ensuring the constitutional values, they play a very vital, very constructive and very positive role.
Yes.
And therefore, we are rather, in a way, we appreciate their timely exposure
Yes,
to this
they-
important otherwise damage would have been completely irreversible.
Lord, mainstream media is always responsible. Lord, there are tabloids, Lord, virtual platform tabloids. Their main job is either blackmailing or something.
Of course,
We can't help it. Lord. That's
many a times we individual are made target, but we ignore all these, because we know that.
they deserve to be ignored only.
As your lordships ignored that other matter where we filed that criminal contempt, your lordship said that we will not deal with an individual. But here this is something which is affecting the institution.
Yes, Mr. Vikas Singh knows that. On that day also we said we are very large. At least in that way, we will not.
That's the majesty. But this would be, Lord, this should not be, Lord, go
This is
unnoticed.
here the institution is involved.
Unpunished.
Thank you very much, all of you, that you have stood by our
Deeply obliged.
principal, and I'm so happy that personally and all my brother and sister and all the high courts are also. In fact, they are looking towards you that in crucial moments, how the institution we all stand together and we defend the autonomy, the independence which this institution has always enjoyed all these 75 years. Thank you very much for your. This matter on opening on 11th March.
Please.
Please.
Oblige.
Eighteen, yes. My lords, I'm seeking for a short pass on.
Also, why? What is the matter?
My lords, on the last date of hearing, there is nothing, Lord, remains to be done. Already, almost the trial is concluded. Therefore, the bail may be confirmed now.
Now,
My lords, my humble submission is all the witnesses, almost all the witnesses have been examined. 3 witnesses have been done in the 15 days when he was in jail, and the examination of other 6 witnesses have took 6 months to examine them when he was out on bail. My lord.
That's right, but our courts are also hard pressed. Sometimes they also, it's not that they are privileged. Otherwise, you're not creating any problem.
My lords may direct to conclude the trial in a time bound.
We will do that, number one. Number two, it is always subject to scrutiny. If we again indulge in anything, if we got him arrested, we will again do it. If we find that he violates, bail is always conditional.
The lordship's order has had the desired impact. He's appearing. Those are my instructions. I appear for the state.
So,
My lords may direct to conclude the trial.
we are informed by learned state council as well as the council for the petition that the trial is going on and a substantial part of the prosecution evidence has been led.
My lord.
There is no incident of misuse of concession of bail. This is response number one, na? By
Response number one.
By response number one. Shri Manan Kumar Mishra and Senior Counsel representing response number one assured that he will fully cooperate with the ongoing trial and shall also abide by the conditions imposed while releasing one interim bail. As of now, we see no reason to keep these proceedings pending. The interim bail granted to respondent number one is made absolute till the conclusion of the trial, subject to the condition that respondent number one and his counsel shall continue to cooperate with the ongoing trial, and shall not violate the conditions imposed while granting interim bail. We direct the trial court to make an endeavor to conclude the trial within 6 months.
Much obliged. Much obliged.
Point case in Gujarat.
This is that Bitcoin, my lord, you should recall.
Hello.
Continue.
This is the case, my lord, where I was kidnapped. Police officers were convicted. I spent 16 months in jail. Then a lordship granted me interim bail. These are those 4 facts, my lord.
We don't know who kidnapped whom, but
No, but my lord, there is a conviction recorded where I am
it
the.
is the same kind of mystery as it happened in case of Bitcoins. What are those coins? Who possess? Where to possess? What is their value? But all said and done, Sanjay is now on interim bail.
No, my lord, sir, your lordship will appreciate only one aspect, my lord. That so far as he is concerned, my lord, we could not know earlier the magnitude of the crime, my lords, and the transactions which was done by, my lords, the main person Kumbani, and how he came in picture. He says he is presenting himself to be a victim, but actually he is not a victim, my lords. Now he is also virtually a co-partner in this business, my lord, of illegal business, my lords. Now, my lord, on the last occasion, it fell from Honorable Justice Joymala Bagchi that why did the other person was not arrested, my lord. Now, my lord, the difficulty with us was that by that time, my lord, because of the statutory requirement, we had to file the complaint. Now, we filed the complaint in time, otherwise our complaint would have been beyond the time, my lord. As a result of that, because of the judgment of this honorable court in Tarsem Lal's case, because once the complaint was filed, then we could not arrest him, my lord, because he was in the court custody, my lord. So that was the thing. Both of them are in custody of the court. Now, Dhaval Mawani and my lord Kumbani, my lord. Kumbani is the main person, my lord, behind this. Dhaval Mawani was an operator. Now, he was a technocrat, my lord, and who was doing the main thing, my lord, for, my lord, him. Kumbani, my lords. Now, my lords, so far this person is concerned, in his mobile phone there are a lot of informations, and for some time we need his, my lord, interrogation, my lord. So, subject to...
My lord, I am going to their office every day. Every day I am going there.
For months.
Confirm my order will be done with it.
Observe that he will fully cooperate.
I show you the number of hearings that I have attended in the office, my lord.
We have heard from saying counsel on behalf of the petitioner as well as the Judicial and Additional Solicitor of India, Justice Judicial and Additional Solicitor of India, on behalf of the
ED.
on behalf of the Directorate of Enforcement. So, having regard to the facts and circumstances of the case, or without expressing an opinion on merits, the interim order granting releasing the petition on bail passed on 18th December 2025 made absolute, subject to first convenient conditions as are mentioned in that order.
Worship.
As are mentioned in that order.
Grateful.
Lord, I think it is recorded that he will fully cooperate with me. Lordship. That way.
So, without saying that, if so required, the petitioner will join the investigation and will fully cooperate. Will join and fully cooperate with the ongoing investigation.
Grateful. Grateful.
May it please, Your Lordship. My Lord, in item number 20, I'm appearing for the petitioner who is a rape victim, my Lord. The state has filed its reply in both items, my Lord, supporting my case and seeking rejection of the bail granting order. Respondent number 2 has been served, my Lord. However, no one has entered appearance.
Now he is saying it that.
No marriage. We say there was marriage. How the children have.
My Lord, Registrar Marriages has passed a detailed order. SHO has confirmed that there was no marriage, no such.
That's it. You are only prove your case during trial.
I'm not
for bail. We are examining the bail issue, but prove your case during trial.
My Lord, the respondent number 2 has not entered appearance. Then Your Lordship will.
We are entering appearance on behalf of respondent number 2, and we are taking 2 weeks to file our counter.
Very well, not, because I would also like to place on record a judicial order passed by Honorable High Court of Allahabad saying that he has committed fraud on the Honorable High Court, my Lord. If my colleague is given time to file a reply, then let me be also given 2 weeks time to file my rejoinder. And very critical document is there, my Lord. I would like to.
Counsel for respondent 2 seeks and granted 2 weeks time to file the counter affidavit. ये बच्चों को टाइम दे ये हो जाएगा ये पोस्ट मैटर ऑन इट
All right.
Great.
ये हो जाएगा सुनाने में
Well, this is that alleged scam, Malaj, probably rightly so. And Malaj, I have served 4 years and 3 months already under the main matter, Malaj. Now, the offshoot of that is both, Malaj, GST and excise, Malaj. And Malaj, as far as GST is concerned, Malaj, there is no arrest because it's a complaint, Malaj. It's a complaint procedure, so there is no arrest. Under excise, Malaj, the maximum imprisonment is 7 years, Malaj. I've already served 4.5 in the main matter. Malaj, the only point now is, Malaj, he says I did not cooperate. I couldn't. I was arrested. I was arrested from September 18 to 2023, Malaj. And he says I did not cooperate from 2018. But Malaj, I was in jail throughout. So I could not have cooperated. They accept the fact that these are bailable offences.
I was सबको चीज किया था about 40 cases against me.
In any case, everything that I've got bail under PMLA also, Malaj.
In this case. In this case, 3 months.
No, you are right. Malaj, I got bail under PMLA. I've got, Malaj, that means for every other offence under excise, I'll have to separately undergo. Malaj, that your lordships don't encourage that. Malaj.
secure the interest of because he has been
No, everything is attached, Malaj. There's nothing I can do, Malaj. Under PMLA, everything is attached. And now the complaint has been filed also, Malaj. So they don't need me. Malaj, bailable warrants were issued, I appeared and they took me in custody.
The outstanding amount is around 54-55 crores. So at least put in some money.
No, they have all attached, Malaj. I have no, everything is attached, Malaj. Malaj, just notice this fun fact. There were bailable warrants issued. I went there and they put me in custody. And I was not arrested during investigation, Malaj. And Malaj, they acknowledge the fact that custody and interrogation is not required, Malaj. So your lordship is right. I'm not disputing, Malaj. There is a scam. There is a scam.
For me personally, it's a big loss and shock that in a small town like Hisar, to which I belong, this kind of fraudulent people are starting.
People have a genius mind, Malaj, in our country, Malaj. They can do anything. We have seen that happen time and again, Malaj.
The modern mechanism of recovery of tax dues will be determined by the next rate of law.
Deeply applies to Malaj. Sometimes it's difficult to appear for such people, Malaj. This is also a tough job.
Same matter notice.
Similar matter.
May I please, my lords, two similar matters, my lords have already issued notice.
What is the date? Any idea?
My lords, tentative date is shown as 27th, but I don't think so it has come in the list till now. My lords, may tag along with those matters, then it will be automatically picked up.
All right, say, issue notice, tag this one second.
My lords, there's a stay in those matters.
So there is no need to repeat stay, you are an association, stay is already there.
My lords, also there's some refiling delay.
That is done.
Yes, my lords. My lords, may tag along with those matters so that.
That's right. We have already complied with your directions, Riga.
Yes, my lord. Oh.
I appear for state of Kerala in the matter, I accept notice. I appear for state of Kerala in the matter, I accept the notice.
Item?
22 months.
Kerala, the packaging.
Date of notice. 4 weeks to file reply?
Please, my lords. 4 weeks time may be granted to file reply in the matter.
23?
Grateful.
Notice?
Unless the arguing counsel is appearing through VC.
All right, for us, you are more than sufficient. We are issuing notice. We are afraid of you only.
Grateful.
Item 24.
My lord, in item 24, I am seeking short accommodation.
Now,
My lord, I am seeking short accommodation as main arguing counsel is not well today. He has to leave the premises due to medical exigency, my lord.
circulating letter sources to any arguing counsel is stated to be here. Well, उसकी बात तो आसान से करो।
Much obliged.
अपने वीक को लगा दो उसमें। ज़्यादा लंबा नहीं करना, फिर पढ़ने दोबारा पढ़ना पड़ेगा। Theoretical petition. If you have reasons to suspect, you have every right to enter the premises.
Is that
You have reasons to suspect, sir. The statute is very clear.
yes,
Search is on reason to suspect, seizure is on reason to believe.
yes.
So if you get information, it's not that you will have a certificate and then enter. The High Court is very correct. It's absolutely correct. If there is tobacco in the hookah, you have right to go.
Yes.
If you have information, credible information, होगा तो सारा कुछ है। लेकिन इनकी ऑफिसर मिले हुए हैं। टोबैको भी होगा, उसमें नार्कोटिक भी होगा। वरना बॉम्बे में नहीं, अदरवाइज बॉम्बे में आपको सौंफ इलायची का हुक्का थोड़ा पिलाओगे। Must have been your officers are handling the law. That's the whole problem.
No, the lordship problem is that once we receive a information that and when we go there, they are showing these orders and saying that you cannot enter the hotel.
No.
And they are disturbing the.
That is why cases, sir, where you under the NDPS Act, you have right to search and seizure the premises. Once you have a suspicion, reason to believe, yes, COPTA all give you the same architecture.
Yes.
And levels of satisfaction are different. Reason to suspect, reason to believe is different.
Lordship, I'll leave it at that.
Forget about that. You can also have a trap. You put in someone, let him go and buy some hookah from there. That itself will give you basic information to register FIR and go in. And we not that if this affair is question, it's end of the matter. You can always lay trap in the such circumstances of this case. Provisions of the Cigarettes and Other Tobacco Products Act 2003, etc. Somehow we see no reason to interfere with the influence of particular.
Lordship.
May it please your Lordship. Lord, 26. This is regarding, my Lord, setting up of a crematorium right next to my house. Right next to my house. Now the rules for crematoriums, there are Tamil Nadu rules which are, my Lord, at page 33 of the paper book. If your Lordship first sees section 7 at page, rule 7 at page 34, it says, no person shall bury or burn or cause to be buried or burnt any corpse in any place within 90 meters of a dwelling house or source of drinking water supply other than a place licensed as burial and burning ground. Now your Lordship may read Rule 5. Rule 5 says, no new place for burying or burning the dead, whether private or public, shall be opened, formed, constructed or used unless a license has been obtained from the village panchayat on application. Now, my lord, the High Court, unfortunately, has interpreted this to mean that if the panchayat gives a license within 90 meters, in my case, my lord, it's right next door, it's 10 meters away, then Rule 7 will not apply. This is their interpretation. Now, my lord, if a purposive interpretation,
Mr. Bhushan, the three-bench judgment, the three-judge bench judgment
of the High Court,
yes, Jagdishwari,
Jagdishwari,
has it been challenged before this court or it
I
is
don't know.
final and binding? It is because
I don't think it has been challenged.
It's a one proposition which has been a very time-tested proposition that when it comes to local laws,
yes,
and we would generally defer to start decisis. Now, if a law
Generally, you are
is
not
settled
right.
in respect of a local regulation,
So, Lord,
and,
here
why
the
should
question
we
is,
start?
Lord, is it reasonable? Is it reasonable to
So we
say
understand your argument.
that a new crematorium is opened right next to my house? It's creating a huge nuisance. Every day, my lord, bodies are now being burnt there for the last couple of weeks.
It's not an open kind of cremation ground.
No. This is a crematorium. This is, if your lordship appoints a court commissioner, any commissioner, to go and see. And then, my lord, this is despite the fact that there are a very large number of crematoriums, some owned by the same organization which has set up this crematorium. Right next, within a few kilometers. One is 2.7 kilometers away.
But growth of population, with growth of population.
Actually, my lord, this is a tribal area.
In this country, you may, anybody can say, I don't need a school, I don't need a hospital, but crematorium is one place everybody needs.
Yes, the question is, my
I
lord.
had to take judicial notice while in High Court when this Haryana Urban Development Authority in Gurgaon started giving private right to private builders, even the land which were earmarked for Shamshan Ghat or cremation ground.
In this
I
case,
had to take judicial notice, then I intervened, then I compelled them, each one of them, to earmark.
I understand that.
You develop 20-story residential house and don't give a cremation ground.
So here, my
As
lord,
if everybody will be immortal living there.
Here-
Same thing happens here also.
here, my lord, they have set it up right next to my house. Secondly,
When was your house constructed?
many years ago, 60 years ago, according
He
to,
doesn't tell you,
according
he has
to
sold
my
half his
information.
flat to us.
60 years ago.
And because we,
No, the fact that you are here, why don't you buy his entire property?
correct, so I'll tell you,
And settle him with that a good, nice place.
absolutely right. You know, your lordship knows not, we are Isha Foundation, our total area is 200 acres. This is not a plot which is absolutely open, eco-friendly, LPG, we don't burn wood. So this chap, my lord, came and said, you buy my land. I bought 5 acres of land, my lord, what he had. Now, this, the remaining land, my lord, he got it, my lord, in his wife's name for landless agriculturist. Therefore, that can't be sold. Otherwise, I am willing to buy. I have said that in the counter. So this is the real reason for moving this petition.
Actually, my lord,
He has
This-
5 acres which I could buy.
this Isha Foundation,
Can't buy, that's my problem.
this Isha Foundation, my lord, the local
Lord, have a look at
tribals
page
who reside
145.
in this area, their custom do not allow them to burn their dead. They bury them. This is a tribal population. What they are doing is, they are bringing these bodies from hospitals from the city which is 30 kilometers away from Coimbatore city. And they are saying that if you burn it in this Isha crematorium, you will attain moksha. This is the kind of,
Person of box, this is
Let's not go
it's
there.
a very pious social service if that.
pardon Lord?
Then nothing, it is not a religious service, it's a basic. If you look at the hygienic conditions, if the dead bodies remain unattended.
Lord, why should they construct this crematorium right next to my house, right next to my source of
Understand that
water?
difficulty, that's why we are trying. Now, house part,
You know, 5 acres of land he had, I bought.
Just see,
Then I
Lord,
should turn to page 145.
just
It's
before
very much
that,
there.
Lord, just
He
see
should
the
have told
existing
this.
crematoriums in this area.
have you sold your part of the land to them?
Pardon Lord?
Have you sold your part of it?
Yes, part of the land was sold to them, but not for the purpose of a crematorium.
How do you?
Not for the purpose of the
Seller
crematorium.
can dictate, Mr. Bhushan, that I am
But
selling
not-
land condition. You can't impose this condition that land.
No, Lord, suppose somebody buys my land and then starts some activity.
You
which
can
is
always say
creating-
you sold for lawful activity.
Yes,
You can only claim that you sold for lawful activity.
correct.
Not for, because nobody.
This is not a lawful activity because Rule 7 clearly prohibits setting up a crematorium within, within 90 meters of a dwelling house.
Just a minute. Mr. Rohit, the rest of the land, which is probably because of the statutory embargo that he can't sell.
Yeah.
But so far as house part is concerned, where he is living, that he can sell to you probably. House is there is no bar for that. And you can compensate him so that he gets.
I have no problem, Lord. If there is any saleable land, I will buy.
I have been living there for the
problem.
last 60
Any
years.
saleable land,
My
I will
family has
buy,
been
like I
residing
bought
there
5 acres.
for the last 60 years. My,
Bhushan,
yes,
we have so something, not every charitable institution come forward for this kind of services. If they provide it, we understand living there, even if there is no pollution or anything, sometimes people get psychological stress. It leads to a psychological stress.
Your Lordship may just send
When
some
you
court
see that
commissioner.
body, then you realize that,
See
oh,
what
I
is
am also
happening,
die
my
someday.
Whether, my lord, it's psychological, whether it is physical, your lordship can imagine if I am living right next to, the boundary wall is adjacent, my house is right adjacent, 9 meters away from the crematorium.
Therefore tell him that he can find out some suitable.
See the stench and so on.
He can find out a suitable place, and we will persuade them to compensate you so that he has a better living condition at a place of which right.
I go down, Lord, to the Chief Justice's
I can
go down.
I can
give
I
whatever
can take
compensation
instructions. I can find out as
Because nowadays there is a common tendency throughout the country. People go from village to some township or some nearby better area. So in Coimbatore type area, this is a well developing area. So he might think of.
I'll ask him, my lord. I'll take instructions.
This is outside.
Just see the one table your lordship may see at page 111. Just see this table of the number of crematoriums in the vicinity. Within 5 kilometers, so many crematoriums are there, so many. And these villagers don't need this crematorium because they don't they are tribals. They don't burn the body.
Sorry, my lord, they don't.
They bury their body.
Right outside Coimbatore.
Here, my lord, they are coming, they are bringing the bodies from Coimbatore city, from the city hospital, which is 30 kilometers away, in order to burn them
They are
here.
doing it free.
This is the problem.
As a matter of charity.
That's good.
Europe and other countries, we are not saying that, but people have, because of the space constraint, and burial itself has become a very costly affair, which the families can't afford. Now, the only way out they have found out is that you burn the body, and then ashes are ready. Because that's the only way, and it's the only scientific way of.
That is
Most scientific way of.
that is for the local people, the tribals, to decide as to what they want to do with the bodies. If their custom and their religion says,
It's not your case that this organization is compelling the tribals to burn their dead.
No, I'm not saying that.
They are just offering a crematorium for people who wish to
What
burn
I'm saying is this, my lord. What I'm saying is this. Under Rule 7, the village
7
panchayat,
is to perhaps we will not be with it.
under Rule 7, the village
Rule 7
panchayat.
is clear. Other than crematorium license.
Yes, now the
So
question
we have
is
to
if
read
the license,
harmoniously, 5
the
and 7.
license has been given at a time when there was an existing house within 10 meters, then the question is, my lord, whether such a license can be given despite the fact that there is Rule 7 which says that you will not burn within 90 meters.
If you see, the reason is,
Yes.
there were two forms of disposal of dead bodies.
Yes.
One was at a licensed crematorium, another was through local practices,
True.
at their own residences, or informal places where ancestors have been burned.
Correct.
So to take care of this unregulated cremation of bodies, 5 and 7 were introduced, that even if it is a licensed crematorium, then the distance, spatial distance issue will not
I
come
understand
into
what
play.
your lordship is
If
saying.
Otherwise, the spatial distance.
I understand what your lordship is saying. The question is whether a purposive interpretation of these two rules, harmonious interpretation.
This is why we are saying, a three-judge bench of the jurisdictional high court has interpreted a local law. Why should we not defer this?
That's because, my lord, it violates, my lord, my fundamental rights, because I can't live there. I can't live there with this kind of stench of burning bodies coming.
We don't think so.
From right.
Innumerable crematoriums are within city limits.
No, if there is an existing.
You go to Chennai, you go to Coimbatore. I don't know about Coimbatore, but I can definitely say about Chennai that within 50 meters of human habitation crematorium is there.
But, my lord, once there is a specific rule.
It is as important as hospital, Mr. Bhushan.
Very well, your lordship may. I'll try and take instruction.
Let us see. They are kind enough to carry a respectable way out to his satisfaction.
Not the crematorium
I'll
here in
ask
Lodi Road. There are houses within 5 meters.
No. There are no houses within 5 meters. That is not correct.
Oh, wow. We don't go
That
to
is
Lodi
not
Road.
correct.
Right behind Lodi Road is Birbal, Jangpura extension. What are you saying?
No. That is quite far.
We'll take Mr. Bhushan to a more unplanned city, that is my city. We'll have a crematorium cheek by jowl beside the Ganga.
Yeah.
Because the Hindu practice is
Yes.
the disposal or the cremation beside the Ganga is more pious. And the houses are alongside, and the crematorium is a cheek by jowl.
You know,
Maybe.
all along Haridwar,
Maybe.
Har Ki Pauri, that is
Maybe.
there now.
But
They are
advisedly.
there in the middle of Delhi, Kashi. Lord, I don't think your lordship should interfere.
The most pious place.
Correct, that has happened.
But
I'm telling you
there
about
are,
Delhi. Yeah.
Delhi is more planned.
No, those residences are also not that close to the Ghat.
Yes.
No, not
Just across.
I've been there. I've been there. They are also at least 50 meters away. Here, my lord, they're right next to my house. It's impossible for me to live there now. It's impossible because.
They are offering something. Please.
Very well, we will consider that, my lord. Let them say what is their offer, etc., and then we'll see.
This is the point. And you should not use anything in the social media.
The interesting responses are on caveat.
Later appointed to find the value.
You have heard the translation on concept of the petitioner and referendum. The documents on council on behalf of the foundation. On our suggestion, the parties are agreeable to explore the possibility of an amicable settlement in terms whereof as number 2, foundation will offer a fair and reasonable market price for the residential house of the petitioner, so as to enable him to settle down at another place of his choice. We are earnestly impressed upon the parties to explore such possibility and settle their dispute amicably. Post this matter for further consideration on so and so date.
My lord, no posts in the social media, my lord. There are lots of posts in the social media about us.
That should stop, my lord.
Ask Mr.
about this.
Mr. Parmeshwar is a trained mediator.
Train mediator.
Let him talk to Mr. Bhushan and through the other assisting counsel. And we tell him also to be reasonable. They will also be reasonable.
Certainly.
Both sides. This is how the disputes are always resolved.
We'll try. Your lordship may have it after a few weeks.
After two weeks.
After
R13.
more time, your lordship may get because
After
then
4 weeks.
after 4 weeks.
Because we are R13, not R2. R2 is the pollution control board. We are R13. We are R13.
Please, my lords. My lords, these are matters similar to RIA builders and BD Vivek, my lords.
If your lordship may ask the parties to come for mediation in that matter, here by some mediator here, that would be more useful. If your lordship asks some mediator here, that may be better.
My lord, we will first ascertain the market value and make an offer to him. Let him accept or reject, my lord. It is as
Let
simple
them
as
come
that.
before the mediator and tell us what they are offering.
The simple question was, let them give us a price we are willing. No problem. We'll do that. We'll do that. We have no problem.
Anybody, my lord, anybody.
We'll do that.
V. Rajendran, a former judge of Madras High Court, who is, of course, he is settled in Chennai only, but he belongs to that area.
All right.
To provide his services as mediator between the parties.
Very well.
Between the parties. The counsel both sides are will contact Mr. Rajendran by tomorrow, and then will then appeal as per the schedule that may be fixed by Mr. Rajendran.
Very well. Very well.
My lords, in item 27, this is a matter similar to RIA builders and my lords BD Kapoor, my lords, BD Vivek. And against the same impugned order, my lords, a notice has been issued for other performer respondents.
No challenge in respect of 3G5.
My lords, we have, my lords. May I-
Here will not do. You did not take out an application in 2015 against the award. In 2025, you move a writ petition after the amended award, giving solatium in light of TARSEM. Now you want to hop into this bandwagon.
May I just pass an order, my lords, where notice has been issued for the other performer respondents.
Milord, can I make a submission? I appear in 27.3. Dear Milord, there were number of petitions in which one of the petitions.
Madam, did your client take out the civil applications in 2015-16, which is the lead case being special level civil application number 5504 of 2015? If yes, yes, otherwise no.
Milord, we have moved draft application for Milord seeking the constitutional, challenging the constitutional validity of section 3G. But Lordship may give me 2 minutes hearing, Milord. Lordship may give me 2 minutes.
Arbitrator with 3-5 because if there's a notice, everyone wants to jump.
My lords, against the same impugned order, notice has been issued, my lords, in this court.
Not in
And it is pending. It is, my lords.
all these add-ons of mountains of petitions as
Milord, these people are Adivasi people. My lords may appreciate, Milord, they belong to scheduled tribe. Even approaching them, Milord, to the High Court is a difficult task for these people.
People have been benefited, madam, with the amended award. Let them be happy with it.
May I just show something, my lords, because
Milord, for the very same, against the very same award, the coordinate bench has issued notice before 5 days. Lord, we only make a request, these matters may be tagged along with.
Not at all.
We don't know because there is where the facts were brought properly or not. SLP sheet number 70137 we are talking.
Lord, in fact, we have challenged the entire proceedings before the Honorable High Court so far as Land Acquisition Act is concerned. Lord, we
70137.
Yes, my lord, it is 70137 of 2020.
So let's post these matters for hearing and so on to get. SLP seal diary number 70137/2025 be also placed before this bench along with his wife.
Highly obliged, my lord, grateful to my lord.
Yes, my lord. This PIL raises a very, very important issue which goes to the root of our democracy. And that is the unregulated use of money power by political parties for election purposes. Today, my lord, under the law, there is a limit on the expenditure of individual candidates, though that limit is unfortunately not enforced very often because people spend in cash, they spend much more in cash, etc. But there is a limit.
What your proposal is giving, there is something beyond the proposal also.
Yes.
You see the US elections, there are there limits to spending by party. In the friends of candidate A,
in UK,
pacts,
there are. Yes.
pacts. The pact you create. Let us say an Indian-American pact will fund you. Where is the limit?
No,
You contest the election, your political party will be banned. But friends of Mr. Bhushan, they will fund.
Your lordship is right. There are many problems in many laws or in many jurisdictions across the world. But in India, my lord, this court
say we will put the embargo, no funding beyond X limit.
Yeah.
You will come before us saying 19(1)(a), freedom of expression, expression through material support.
no, my lord, with great respect.
How will we control that?
So the parliament advisedly put a restriction on candidate.
You want it to be enlarged to party.
Yes, yes.
Now, will that be sufficient? Because
that may not be sufficient. I am not saying that it will be sufficient. I am not saying that. What I am saying is, my lord, of course, if I spend money on behalf of a candidate, then normally, my lord, it is calculated in his election expenditure. But if a political party spends, that is not calculated. And unfortunately, my lord, there is no limit either on political party as a whole. Look, this is the maximum what you can spend in a year or whatever. And there is no limit qua every election or qua candidates in every election. And the election commission, apart from this court in constitution bench in electoral bonds, my lord, has said in large number of paragraphs that this is a scourge. This is a huge problem. This is skewing our electoral democracy because there is unbridled use of money power by political parties in elections, etc. And this needs to be stopped. This needs to be curbed. Now, election commission itself in
That this matter we also heard along with petition serial number 1290/2021. No,
which is that matter, Milord?
there is one matter pending.
Acha, I'm not aware of it.
That is disposed of.
No, that is disposed of, Milord. 1290 is disposed of with direction saying that that was on a different issue. That is not on the expenditure by political parties as such. That was only on one part of this problem. That is,
There is one more matter, I think, they have to, we don't know.
That is on freebies.
No, no, there is separate petition in 2025 on the
On-election spending.
not per se, but it's a restriction.
it is on freebies.
No, not freebies.
Not freebies. Yes. There's one matter, if I remember.
Yes,
correctly,
my
on the
Lordship issue notice in
on defining the
yes.
maximum.
Yes.
Maximum limit.
I will give the rate number, my lord. I will give the rate number.
Oh, this is. Anyways, we can notice, then we'll see.
I think it's in September.
I think your Lordship may just issue notice because that other matter is not really pending. Returnable on some date.
Yes, we'll give it.
I am applying.
Yes. But the false cases, my lord, the biggest barrier, my lord, we achieve the goals, my lord. The false case.
But this issue, people will, you have to be ready, people will criticize us, saying that this is another way of dragging them out. They will accuse us of doing this. But why one should be afraid of dragging? If you are a responsible citizen, then you will own the responsibility and say that yes, what I am saying is correct. Because people make abusive language, they try to defame people, and then they disappear from the scene because they know nothing can be done. So some check and balance is required. The way it is being abused.
It's happening, my lord. I travel 100 to 120 districts every year, my lord. Every Saturday, Sunday, entire summer vacation,
At least this was suggestion that on police station, railway station, display board, that if you
yes,
make false
my lord,
complaint,
what was the issue in this UGC issue? उनका ये कहना था कि कॉलेज में आपके ऐसे फॉल्स केस होंगे. अगर वहीं एडमिन जो ब्लॉक है वहीं पे एक बोर्ड लगा दिया जाए कि दिस इज फॉल्स केस सेक्शन सो एंड सो, इम्प्रिजनमेंट सो एंड सो, फॉल्स चार्जेस सेक्शन सो एंड सो, दिस इज, मतलब इट विल control the fake cases. Lordships are overburdened not due to the real cases, my lord. Lordships are burdened due to the fake cases. Particularly district judiciary, my lord. Particularly, I am giving 2-3 examples, my lord.
by the time
झगड़ा होता है खेत का और मुकदमा लगता है SC/ST एक्ट का. पति पत्नी में झगड़ा होता है और नंदन नंदोई सास ससुर सबको उठा के डाल दे, सबके खिलाफ शिकायत हो जाती है. क्यों? क्योंकि फर्जी शिकायत करना अपराध नहीं. झगड़ा होता है किसी और बात का और लग जाता है मतलब रेप का केस. अभी इसी हफ्ते क्या हुआ है, मध्य प्रदेश में एक बड़े स्वामी जी की कथा शुरू होनी थी, वहां एक नेताजी को आना था, नेताजी नहीं पहुंचे. स्वामी जी ने मन से बोल दिया, नेताजी ज्यादा बिजी हो गए होंगे इसलिए नहीं आ पाए. वो बात बुरी लग गई, सीधे रेप का केस लगा दिया. जो स्वामी जी एक हफ्ते कथा करने वाले थे अंडरग्राउंड बाहर घूम रहे हो, अंडरग्राउंड बेचारे घूम रहे, वो बेल के लिए घूम रहे. तो मतलब ईमानदार, मतलब प्लीज अप्रिशिएट, मतलब ईमानदार लोग डर डर के रह रहे हैं क्योंकि एक फेक केस से बाहर आने में विष्णु तिवारी को 20 साल लग गया, नंबी नारायण को 15 साल लग गए. मतलब पूरा हमारा जो गांव का जो फैब्रिक है मतलब ना पूरा डिस्टर्ब हो रखा है. मैं प्रयाग का रहने वाला हूं, मतलब लगभग हर 2 महीने में गांव जाता हूं. वहां जाके एक ही बात समझ में आती है कि गांव में जो झगड़ा हो रहा है, एक दबंग दूसरे जमीन पे कब्जा करता है, वो गांव वाला जो गरीब बेचारा अपना लाठी लेकर खड़ा होता है, वो दबंग किसी के उसके खिलाफ कोई केस करा देता है. फर्जी केस, फर्जी वो केस, रेप का केस, छेड़छाड़ का केस, अपने घर की महिलाओं को आगे कर दिया. ये हो रहा है. मतलब तो जमीन का विवाद तो बाद में गया, मतलब
केस चलना था एक सिविल का केस, उसके बदले 2 केस क्रिमिनल कोर्ट शुरू हो जाते. This is the reality, my lord. I filed many petitions, my lord. I am saying that this is the most important petition, my lord, to ensure the right to life, liberty, and dignity. My lord, just give me 2 minutes.
We need to create a very informed society. A lot of sensitization of the people to understand the value of if you are a person, they are always thinking of their fundamental rights. They need to learn about their neighborhood fundamental rights also. Unless we cultivate that culture.
Just see the prayer. Please see my prayer. It's not adversarial petition, my lord.
Foundational principle of fraternity. Unless we cultivate.
My lord, just see my prayers. This is not adversarial petition. I am only saying, मतलब थाने पे अगर कोई आ रहा है FIR लिखवाने, अगर ये रिस्पॉन्सिबिलिटी हो जाए कि एक बार उसको ये कह दिया जाए कि जो कह रहे हैं वो ठीक है ना, क्योंकि ध्यान रखना ये सेक्शंस हैं जो झूठे केस के हैं. आई एम गिविंग अनदर एग्जांपल, वाला जस्ट सी माय एफिडेविट एट पैरा पेज नंबर 24. So for filing this PIL, I have given 11 undertaking, right, my lord. Then I verified that all the 11 things is right. अगर इसी में एक पैरामाइलट और जुड़ जाए तो मुझे ये भी पता है कि फॉल्स केस, फॉल्स एफिडेविट फाइल करना अपराध है. मैं बिल्कुल नहीं करूंगा, कोई नहीं करेगा. इतना इफेक्ट होगा. अभी लोग फॉल्स एफिडेविट फाइल कर सकते हैं, लेकिन अगर उसी में BNS का प्रोविजन लिखा हो, उसमें पनिशमेंट लिखा हो, मतलब नहीं होगा. देयर इज अ सेक्शन, मतलब this chapter 14, my lord. Section 14.
So further problem will arise, and problem is actually that when these false complaints are lodged, the de facto complainant does not know even that he or she has lodged a complaint. It is someone else who gets some impression, blank signature, take him to the police stations and other places. The poor fellow doesn't know even that I am being exploited by another affluent person.
My lord.
This is how it happens. Case, the wife coming to us telling that so and so political leader is not involved in the murder of my wife. Now this statement, where is the necessity for her to make a statement before us? Unless either she on the gunpoint or on the PowerPoint or power plus point.
Or the money point.
Money point.
Yes. My lord, just see there.
What kind of guidelines we can?
Obliged, my lord. Highly obliged. Returnable in 4 weeks, my lord. Returnable in 4 weeks. Yes. Obliged. May it please your lordships. My lords, in all fairness, at first blush, my lords, my view was that the jurisdictional high court should be approached. However, my lords, on a deeper consideration, on some research, my lords, it transpired that there are several states where actually this issue is a pan-India issue, where in fact the ex-cadre posts, which are fixed as per the cadre fixation regulations, which is one is...
About the pan-India, you go and take care of your own state. And go to your...
Well, it's only because the issue is of an endemic nature. That is why. It is only that I, my lords, transpired insofar as the pan-India issue is concerned. And it is an issue. Even the letter which your lordship will see by the central government, where this prior concurrence is mandatory, is not being adhered to. With the result that 1:1 has become, in this particular state, that 1:1, from 7 it became 13. Now there is attempt to make it even more. And there are states, states like Bihar,
the politicians never do this kind of mistake. It's all bureaucrats that they have destroyed their own culture of all India services. Only for plum posting, only to avoid inquiries and investigations against them, only to hide their illicit money after retirement, and only to get post-retired assignment.
Your lordship is right. Melos, in so far as your lordship used the
all
term...
their handiwork.
Yes, Melos, your lordship used the term
fraternities, there's a constitutional setup which regulates this. There's a statutory regulation which is
They have very, very strong
lordship.
the system, how to scratch each other's back.
Because the central government will not say anything because there is something like a constitutional morality where in case the central government says anything, there'll be the issues of center and state.
Go to High Court, try your luck.
Because I respectfully submitted the picture that it is an pan-India issue. However, as your lordship, Because may kindly give me liberty to do that.
This can be recording the business. The petitioner, is to advise, may approve the jurisdiction of High Court.
Very well. And my lords, in case the occasion arises, maybe the matter comes here. It's a matter which your lordships feel does require examination.
One different states.
Lordship, please. Great.
May it please your lordship. Tuning an interim order of the tribunal. Your lordship, on a video, both the district mining officer and the police find no truth. In fact, report that the video. They are asked, action is directed to be taken against the SHOs. I can show the facts, your lordship.
24.
One second. May I? Your lordship, may I show the paras before that, your lordship? Because it shows.
Get into what the
Your lordship, may I, with your lordship's permission?
February. What happened on 18th February?
18th February, your lordship, the state took time.
So you must have also.
Now it's gone
We
to
hope
March.
that you have also
Your
entered
lordship,
here.
but see the report of the state. Your lordship, I'll just show a few paragraphs. May I see para 9 first? Who is the complainant? Person against whom there is FIR even on the 2nd of January for illegal truck. This is the complainant who is again and again producing unauthenticated, unclear videos that is recorded in para 9. Lordship, may see para 9, page 3.
At least somebody is mustering courage to record videography of your trucks.
Your Lordship, videography, Your Lordship, it is seen. Your Lordship, we have seen the video clip. This is tribunal's own finding.
Please go to tribunal. This is only an.
Your Lordship, may ask them. There is a DLT.
Why should we
Your
ask?
Lordship, may I only submit?
We don't consider you such an important person that we should call.
No, Your Lordship, may I just say, Your Lordship, overreach, a fact finding must be done by someone. They can't say everybody is wrong and unauthenticated video is correct. Now, this honorable, the tribunal itself has appointed something called district level task forces. They don't avert to that. They just say that both the district mining officer as well as the SHO are entirely have some lacuna. So we on the basis, Your Lordship, I have to pay my debt rent, my license is not cancelled. I am just constrained from mining authority. So Your Lordship, they can refer to the district level task force. They can get a fact finding report. And basis on that, whatever action has been taken for me for, Your Lordship, operating against GRAP or operating, Your Lordship may see, para 9, we have seen the videos, that's the earlier order. And we find that the video clips do not clearly record mining activity. That is para 9, Your Lordship. Thereafter, Your Lordship, there is an action taken report by the, and Your Lordship may just see one thing on page 7. They were, in fact, sorry, page 6.
Yes.
Page 6, Your Lordship, 4, Roman 4. That is the night, apparently, that video was recorded. That the Assistant Police Commissioner Lori directed the Chowki in charge to visit the said site, that upon the said instructions, the Chowki in charge immediately reached on the said site at 10:37 p.m. Upon physical inspection of the site, no illegal mining activity, machinery, or ongoing excavation was found at that time. So there must be a fact to overturn this. It cannot be on basis on unauthenticated, unclear videos. Similarly, if the DMO, Your Lordship, records and FIRs are all registered against the so-called complainant and the trucks seized on that night are of the complainant. R8 here. It is his trucks, not mine. Yes, I'm coming to that, Your Lordship. I am not going to, I cannot, Your Lordship, escape. I'm coming to that, Your Lordship.
No coming or no coming, you have to, we are not entertaining this.
Your Lordship, may I just come to para 20 and I'll read it, Your Lordship.
Para 20, why to waste your time and now? Your
Yes,
time
Your
is important than our time.
Now, Your Lordship, they say in reverse, we have seen the video clips recorded in pen drive and we find the video clips recorded on 2/1/26 at so and so, so and so, and so and so. Same time that the police is there. Show illegal mining of the sand from the river channel by use of JCB. Now, Your Lordship, they themselves say these video clips are unclear.
Business partners, sir, the police people, the deputy collector, the tahsildar, the local people, all are your.
Your Lordship, which is why there is a DLTF. There is a district level task force meant. Your Lordship, district level task force may find against me. And Your Lordship, thereafter, para 23 and 24 may be seen that in their response dated 21/26, the geo coordinates of the site upon verification was found that only loading, no excavation was being carried out. Para 24, these observations made by the DMO are patently wrong. That is based on an unauthenticated by an interested party. Now, Lordship, I'm only saying that they can make a fact finding, but it must be done. Govardhan also says, Your Lordship, that we must file a reply. Your Lordship may ask them to direct the DLTF and Your Lordship may remand it back. We will submit all the evidence, they can take their call. But it cannot be, Your Lordship, based only on an unauthenticated, unclear, admittedly unclear video, where all the authorities are saying otherwise. Your Lordship, it must be based on some facts. And now they have a mechanism called the district level task force based on their own decision.
So let have lunch in the council for your plan at a considerable length. There is no ground to entitle to sitting against an self-seeking interlocutory order when the matter is still pending consideration before the National Green Tribunal. The appellant commercially advised may move an appropriate application or seek redressal of this grievances before the tribunal.
I'm obliged.
I am in
32 also for
Yes, Mr. Attorney, what is to be done?
No, every tribal this problem is likely to arise. Then that's why the judgment now opened up a certain set of considerations beyond the easy consideration. So if somebody is retiring on 9th of March, 15th of March, things like that, but they were all appointed under Tribunal Reforms Act. The tenure was fixed particular period, 4 years. So to extend what was probably extended persons were appointed.
Whatever now, unfortunately, the uncertainty which is now created, that has to be resolved.
No, that is true. But then whether to extend them to them, the benefit given to those who are appointed prior to the Tribunal Reforms Act is one question. Because all those cases were resolved by this court saying, if they are appointed...
Paragraph 155, recommended before, appointed after the act. That is the protection.
That's right. Therefore, those appointed later, but then the election took place prior to the Tribunal Reforms Act, they will be governed by the earlier terms and conditions of service. But to extend it universally to those who are appointed the Tribunal Reforms Act.
I don't think they are asking for that. They are asking for those cases where the selection committee was fixed under the old rules. Recommendation was made but not acted upon, but the recommendation is acted upon after the promulgation of the 2020.
All these appointments in question were made under the Tribunal Reforms Act.
No, 33 is a different.
Under the Tribunal Reforms Act.
Exactly what your lordship said.
They are not under any other legislation. Therefore, the question to be is, we have to have some uniform principle. We can't have any ad hoc. So there are people who can have additional charges till a lordship is passed upon their order.
Mr. Attorney, as of now, we are not inclined and we will not, there is no reason for us to extend the term straight for 1 year or so.
That's right.
But these tribunals are your creation. Now they have become your own headache. And a headache for you, a liability on us.
It is.
The liability on us. The kind of, barring 1 or 2 tribunals, the kind of orders are coming, the way the tribunals are functioning, and particularly the challenges which are coming before us. And thanks to the legislative regime, we have led to creating a no man land. They are not accountable to judiciary, they are not accountable to anyone on the earth. That kind of system, at least I am not going to approve. But the reality is that today matters are pending, the hearings are taking place. How we can close down them unless we have an alternative mechanism. So
what I will do is, in fact, there are different tribunals, some different days of retirement.
One application I was examining.
In different tribunals. So
in one of the tribunal, I was just in the night when I was examining, I found that if the chairperson is not allowed to continue, a technical member will take.
That's right. He will be an additional charge. Somebody will be given additional charge as a chairperson. Till we take a final call on it. Till we take a final call. I mean, to have ad hoc orders, to pass ad hoc orders in
Because of our judgment of this court, a technical person cannot pass an order.
Right. That's true. But this is a problem created because the court did not envisage all these issues. So how do you iron out all the creases by one principle today? There's a problem we face.
That's why we said, we told you only about weeks and days back.
We are looking into that matter. I'm trying to find out how best we can do that. But in the meanwhile, if this kind of individual cases come up, and then we pass ad hoc orders on that, it's going to be problematic.
No, we are not giving effect to any judgment or anything. We are only wanting there should be at least no functional crisis for the family.
I understand that. We'll not then take it up immediately after the Holy Holidays. I'll come back how to find out some intermediate solution before we come under the larger questions. Because I'm given a lot of information about various tribunals.
Your assisting lawyer attorney accept notice. Post these applications along with all other connected matters on so and so date. Meanwhile, if the term expires, the existing chairperson stroke members may be allowed to continue as an interim measure till further order.
That's 33 is a petition. Your Lordship's only said applications. 33 is a fresh writ petition. Same. Instead of filing an application, we have filed a fresh writ petition.
That's it.
In your Lordship's order. Application stroke writ petition.
I don't mind the entire matter being reheard.
Not item 53, my lord, the same orders. I'm obliged. 53.
There's 32 and 53 only, I think.
33 also. 33 is a fresh.
We don't know.
That's okay. You might not. It's a
In
fresh.
one of the tribunal which is in a very short duration has acquired very immense importance going by the economy of the country. My feedback is, and I'm quite sure my feedback is not imaginary. The technical members are not writing a single judgment, not a single judgment. They are either insisting the judicial member that you write for us also in my name. I know one of the audacity of one of the technical members, and I am waiting for I will sack that member by judicial order. Telling the judicial member that you write in my name, otherwise I will not sign your judgment. Or outsourcing this.
Oh, I see.
Is something which was completely unheard in judicial system. So I am really perturbed about these things, that what the mess we have created. In the name of creating only with an anxiety that High Court should not exercise constitutional power. And in that over anxiety, we have created a situation completely damaging the judicial system, quasi-judicial system. And look at Mr. Attorney, you don't now allow the High Court judges for 15 years, 20-year tenure. They don't now learn environmental law, they don't learn commercial law, they don't learn company law, they don't learn bankruptcy law. And suddenly when they come for how many are lucky like my two brothers, or I was fortunate enough to have almost 8-year tenure. They come for 4 years, then you want them to become expert of everything. Somebody will have to.
In the early 80s, when England was talking about tribalization in a big way, then of course they learned.
What we are only requesting is that some holistic view will have to be taken. maybe that you completely need to introduce a complete new mechanism for this. The tribunals are permitted under the constitution, so no difficulty. But the way these have been constituted, the manner they are allowed to operate, the manner in which they are completely unaccountable, that is not probably in the interest of, in the national interest.
I mean, this question has been addressed at the very highest level. In fact, I'm having almost on a daily basis. So you'll have to give me a little time to address this interim issues. The larger questions are being certainly, yes.
For which, meanwhile, please examine what can be done.
32, 33, 63.
All matters.
Great.
Item 34.
Admittedly, Manoj, in the base case, he has been acquitted. We cannot shy away.
That he has been.
Yes. There is an issue, Manoj, because that forms the fulcrum of the prosecution.
The very foundation, the very basis.
Yes.
Only thing is that against the base case, there is an appeal against.
There is an appeal pending though, Manoj.
In future, if the base case,
there is an appeal pending.
That's what we are saying in favor of your notice that since there is an appeal, in the event the appeal is allowed and the conviction restored, this prosecution may also get some
It's a paradox kind of a situation, Manoj. Both ways, in fact. If the appeal is dismissed and in the meantime, if he is convicted, then
this appeal or this notice can never be heard before if the appeal is allowed.
Pending before the honorable.
If the appeal is dismissed, but if the appeal is allowed and the conviction in the base case is restored, then you have a case to argue.
Then we have, yes.
And in that case, you can always register a press case.
That liberty.
That liberty perhaps can be. That liberty perhaps can be given. Yes.
So we have heard lunch, Shri Shyam Thakur lunch, advocate and additional advocate general for the state of UP. In view of the fact that the first respondent has earned acquittal in criminal appeal number 5295, stroke 2023. By the Delhi High Court, where judgment dated 29th July 2024. No, not this one. Sorry. And by the, what is the date of the judgment of the Delhi High Court?
Delhi High Court is 37. No, Delhi High Court. Yes, Manoj. No. Yes. Yes, that's Manoj.
Page 6.
That's 3/7/2019. I'm sorry. Page I.
That Delhi High Court acquittal.
Yes.
In view of the acquittal earned by the first respondent, for Delhi High Court in
7/19.
Number 1 was acquitted by the Sessions Court, while judgment dated 3rd July 2019, and case crime number 589 of 2005, the view taken by the High Court in the impugned judgment, whereby the proceedings under the Gangsters Act, UP Gangsters Act, so have been placed, is the correct statement of law. And it does not warrant any interference by this court. However, since the criminal appeal number 1178 of 2019 against the above stated judgment of acquittal dated 3rd July 2019, is pending before the High Court of Delhi, the impugned judgment of the High Court is subject to the outcome of those proceedings.
I'm so grateful. And our appeal is well managed.
In other words, if the acquittal of the first respondent is reversed, the law will take its own course, including the enforcement of provisions of the UP's one so gangsters.
I'm grateful. I'm grateful.
Well, this is a mod.
I enter.
Yes, Plus, this is a modification application. These petitions are arising from, there are two petitions arising from cross FIRs. My lords had disposed of and
You are a
remanded back to
threat.
the High Court.
You are a threat to people, including this victim. You don't require any protection.
I was given protection by this honorable court on in the initial date 19th of July itself, my lords. I am just seeking because we are being remanded back from the High Court.
Because the victim has been granted protection by us, the lady. That does not mean that you also deserve.
Well, the lady's FIR was the first FIR. She files an FIR saying that I was your employee, I was sexually harassed. 2 months later, to pressurize her, he files a defamation suit. So therefore, your lordship and your lordship are considering quashing petitions against both of us. He also filed a quashing of my FIR and I filed a cross quashing. The High Court rejected his, dismissed his quashing petition without adverting to my quashing petition at all. And in the process also dismissed my quashing. Therefore, when I...
That's why we remanded the matter.
Therefore, your lordship remanded the matter, giving me protection and saying that by him there should be no protection. Let the trial continue. If he's innocent, he'll be...
But he feels threatened by you.
Since we are remanded back on a fresh notice.
A lady employee.
We are remanded back to the High Court on a fresh note. Everything has to be done on a fresh.
What poor young lady will do against you? Why are you?
Because, Malad, I was given a interim stay by the High Court also, by this honorable court also. Now that when you are remanded back.
But the point is, we only remanded it. We have not set aside that order.
No, that's correct, my lords. But my lords have noted this is for a fresh consideration. So since this is for fresh consideration and with the same.
Go and apply to the High Court. What is the problem where the matter is pending?
Then my lords may say so that we'll apply to the High Court. They'll consider it.
We will request the High Court to reconsider.
Please, my lords.
The instant application has been filed seeking modification of the order dated 19 December 2025. Passed by us in criminal appeal, passed by this court in criminal appeal number 5598 stroke 5599 of 2025. The applicant seeks interim protection against arrest through this application. A perusal of the subject judgment order will show that we have remanded the case to the High Court. The applicant petitioner is so advised may approach the High Court for the grant of necessary, for the grant of the necessary relief. The MA is disposed of with the aforementioned.
Would the court clarify that no opinion on merits has been expressed by my lords in the matter?
Let's expect that we have not expressed any opinion on merits.
Deeply obliged. Please, wait.
My lords, I'm appearing for the petitioner, my lords. My lords, I'm seeking short adjournment as my colleague's grandmother has just passed an hour ago, my lords. So, my lords, kindly adjourn this matter.
All right, all right.
My lords.
Seven my lords may be tagged with this other petition at page 205 is the order.
No pleading of repugnancy in your petition.
Not in mine, my lords. I had taken this ground earlier, but that's now available, my lords. There are several other grounds, my lords, which I am afflicted with. In fact, one of the provisions is this.
The trial is going on.
Well, it's not completely independent of that. In fact, my 482 in the gangsters is also rejected. My SLP is also pending. Correct. Something. So this is.
You have challenged that by way of an SLP.
Correct. So that's been filed. In fact, registered.
As something to add in this matter, not against your particular case. Give the compilation. Actually, this is a challenge to the validity of the UP Gangsters Act. Challenging the particular act. Earlier, there was a writ petition filed before this Honorable Court. It came up before the three judges bench. I am giving that order. That is the first order copy.
Can I have a copy of that?
I'll give the copy. I'm not saying something against
No,
you.
that's fine, that's fine.
Let me on facts.
When you're there, I'm absolutely assured of the greatest
So
fairness.
first that three judges bench, they dismissed by saying that we can't entertain 32 petition. That's first one. Then thereafter, incidentally, in another matter before the Uttar Pradesh High Court, Allahabad High Court, at page number 5 in para 6, they observed that it is redundant. At page number 5 in para 6. Then thereafter, one more SLP came.
Para 6 say this court finds that the provision of section 50 regarding punishment for committing the offence of organized crime, like this one, so on. Therefore, with the incorporation of counsel to clear that provision of UP gangster have become redundant. Oh God.
And madam,
never learn in life.
Yes.
Yes, that is in the oath itself we have taken an oath not to learn.
Yes. And that is the second one. Thereafter, one more SLP came before the Assembly Court, where the Assembly Court permitted the party to file some appropriate petition or impeding application, raise that ground before the High Court where the issue is pending in para 2. At page number 6, para 2 is bottom. We grant liberty, then para 7. We grant liberty to the petitioners to intervene in such petition and support the point which has been noted in paragraph 6 of the said order. That is the third order from this Honorable Court.
The same order which is
Same order, referring to same order. Then thereafter, there is one more 32 petition, which is now pending, and the division benches, the two judges bench that is now considering. That is the order passed in the before this court.
Now, this matter, Manoj, is actually.
One second, let me complete. I'm not saying anything. So now,
When this happens, then all Makoka, everything will go.
So this will have to be tested. I'm sorry.
If this argument is taken to its logical conclusion, that because of 111 in BNS, the organized crime provisions in the state laws will suffer from the principle of repugnancy, then according to you, all the provisions of organized crime legislations in different states will be rendered unconstitutional.
Well, it's the exact same question that the query that your lordships are putting to me is actually under consideration. Please have my petition at 205 for a moment.
That is rare.
So the same question is actually pending before that honorable court. It's part heard. It's listed, Malot, in the next week or so.
What about
top of the board?
Section 26
Now,
of the General Clauses
on the
Act?
principle of MA2 law, etc., the old principle, Malots, of repugnancy, etc., and also, Malots, if there is a new law which has been introduced with the central law, that will, Malots, make the state law ineffective if it covers that. So all of these are considerations which are actually under consideration by another bench, Malots. So all I'm asking today is this, that the matter, Malots, and that too, it's uttered. Please have 205 for a moment, Malots. The learned judicial solicitor general started with that.
No, I want to complete, Mr. Allah, I want to complete, let me complete.
No, this compilation includes 205.
205. So therefore, if your lordship see the top of that.
The issue what they have raised. Now, the issue which they have raised with regard to the repugnancy, now the effect would be, I have given in the first page, chart about the 4 or 5 legislations.
Additional Solicitor General, we are in that is what is troubling us. Therefore, in our understanding, if that general law making organized crime or incorporation of organized crime, can it be treated as a repugnancy at all in case of section 26 of General Clauses Act?
In the event,
legislations create separate offences.
The Honorable Court is inclined to consider it.
Well,
Let
this
all
is
the
exactly the
matters be
question.
here.
This is the same defense which is already taken by them before the other bench.
Let all the matters be
Now the same. All I'm asking today is for all I'm asking today.
The system of dividing Supreme Court in benches is very disturbing for me.
I'm sorry, Manoj?
The system of dividing Supreme Court into benches And that too, of course, it's about, the things don't take place in simpler manner. There are some
Well, that's
challenges with the institution itself.
that is an area where we actually don't have any say. So, well, it's
Let all the matters come before 3
my concern, Manoj. No, this is unfair of my learned friend, Manoj. This is very unfair of my learned friend.
Bench to bench will differ and therefore.
Yes.
So, Manoj, this is unfair of my learned friend.
You see 205.
Correct. That's my concern, Manoj.
That's my concern.
Which is why I wanted to point out at the outset, and this last request which has been made is not fair.
I would like to examine it on administrative side, how the things have moved and how.
Correct.
This should quite disturbing as of now.
That's exactly what I
have yours.
And I did not want to press anything further beyond that, which is why I pointed this out.
And more than that, one more thing, in these matters, I think union also will have to be heard, because it will have bearing on so many states.
All the states.
Yes, all the states
will be noticed to all the states.
Will have to be heard, Manoj.
Karnataka, Odisha.
And there has been substantial hearing. There has been substantial hearing in this matter.
Not less than.
Not as though this was on the first day.
Organized crime, state legislation.
So let all the matters come before the Supreme Court. No
No,
problem.
Manoj, this is again an unfair statement, Manoj, which I object to. Manoj, this is a matter which is part heard. Same plea has already been taken there. They've argued this also there.
We don't doubt the powers of the Chief Justice.
Manoj, nobody is doubting that power, Manoj.
Part of
I
it,
never
but
said that
how we
lordships
know?
don't have that power.
We know so many
My
things.
concern is this. My concern is just this, that today, Manoj, the Solicitor General is standing up and saying that it should all be brought to a particular bench, Manoj. Your lordship is at any other bench, here is at Manoj, it's not my problem. Only thing is, Manoj, I just saw that it was a third matter. Manoj, under the circumstances, allow me to withdraw my petition, Manoj. I'll go to.
No question.
Very well, very well. I'll leave. Very well.
The matter requires a deeper probe.
Very well, Manoj. I will argue my petition.
Functioning of the registry of this court.
I will argue my
The biggest challenge before me is the registry of this court. So I have to hold a deeper probe into that affair. That how the matters, after one bench express opinion, final opinion, how the matters travel to the other bench. What is that mechanism they adopt? So this is bigger. It's a fight every day to day before.
I appreciate
It's not one matter.
Lordships are right.
You will find some matters where you will be feeling embarrassed.
Lordships are right, Manoj. Absolutely right.
That's what happening here.
We've been here long enough, Manoj, to see that
Exactly.
these things. So Lordships may examine that. That's
Despite
correct.
the very stern measures I have taken, you don't know the mechanism I thought I have been able to create, and that will help me in understanding that. But despite that, the things are beyond control.
I understand.
And I was last week there was a complaint received by me. I was nearly shocked to find out that what's happening in the registry of this court. There are employees, there are officials who think that they are here for 20 years, 30 years. The judge will go maximum tenure is good. 8 years. Nowadays it can't be imagine more than 8 years. So they think that we all are here for transit stay. We will come and go. They are the permanent people here. And therefore the things must happen the way they want.
I understand.
That is what bothering me. And if I am not able to bring this in form before I demit the office, then I will be failing in my duty.
We are all Lordships will.
I have.
With your practical groundwork, Manoj.
So please don't withdraw. You have to service. You have to render a lot of service to us.
No, absolutely.
Don't withdraw.
I have a request to make.
Larger public.
May I have your lordship?
May I?
1 minute.
Manoj, I have.
May I have your lordship's leave to make one request?
The bench is.
No, you lots recollect that 17th, 18th, 9 judges bench matter regarding industry. So you are requested to file a submission by 28th. I think if the AG can be given a little more indulgence, I can file my written submissions immediately after reopening, because I'm going to assist the court.
In which matter, Mr. Lam?
The industry, definition of industry.
Industry. Oh no, please, but
The submission to file before 28th, okay, since
by opening.
That's right. So I can file it on 9th by opening.
By opening, then we'll extend this date for everyone.
Very well.
For both sides. Let it be by opening, because date we will not now reach.
No, date is not to be changed.
So I'm not going to reissue the matter.
Certainly not. We are not asking for a change in the date.
Collapse.
I'm grateful to you.
Just a minute, we can't hear it from like this. You are not studying in grey market.
May I mention the same, your lordship is coming back in the same combination?
Yes,
There
we
is
are.
a fresh matter at item 50.
No, for the time being, we are coming in the same conclusion.
Great.
Because there are some matters left.
Correct.
So don't get over anxiety, we are coming there.
There is some urgency.
The special bench, I might think of taking up around maybe 3 o'clock.
All right, great.
3:30. 3 o'clock, बोल दो. You will take up.
All right,
here.
great.
Malad, I am in item 45, so that matter might not reach. The urgency is the petitioner has to just go abroad for his daughter's wedding. Malad, we have filed an application for permission to go abroad. If Malad can just take it up after lunch, it won't take.
How many money you have siphoned?
No, Malad, this was a case. There was some dues with regard to Noida Authority. Malad, earlier also.
75 crores are only left. Tell us which is your property we can auction. Meanwhile, you go abroad. We will order auctioning of the assets today itself.
Well, I'll point out, in fact, this was the case. I had the lease share. I'll point out everything. I had gone to the court and the
Lunchtime, you find out the properties which are free from encumbrance. And during this vacation, you enjoy. You go with your wife, you want to go abroad. Because you have to settle you want to identify the venue of the wedding of your daughter in England or somewhere.
Not venue, my lord, just to meet the
You want to hold
parents
some
of the.
meetings with business people in Germany, in France, you do that, you enjoy that, but meanwhile give your properties which we can auction. You are coming back.
We have filed credentials, we'll point out.
Great.
the petitioners here, they took the examination for the Civil Judge Junior Division for the state of Gujarat. Now, my lord, 6,237 candidates applied for the preliminary exam. Only 211 are qualified against 212 vacancies. Viva voce is yet to take place. Just kindly have page 29. Please have page 29.
See that now. What will happen, Mr. Budwalia, that we'll have to direct the High Court to grant relaxation then?
My lord, actually, there are two orders. One of Punjab, where your lordship ordered an honorable judge to look into it. Before I make any other submission, just have page 29. I just want to point out something at page 29. Page 29 starts from page 28. Actually, the columns are at page 28, but kindly turn to page 29. For 17-18, 75 posts were advertised. Your lordship has got that table, Manoj? For 17,
40 selected.
Only 40 selected.
Then
18, 19,
124, only 7 selected.
yes. Then 185, only 60. Then 219, only 55. Then 212, only 13. 2024, my lord, they were notified, but nothing happened. 2020. Three times we have qualified. Three times we have faced interview. And now this time we have been excluded at this stage earlier only. There are interviews are concluded yesterday. But
so like,
yes,
they will only, even if they select all 211, still vacancies are there.
there are very large number of vacancies. Could it be returnable, my lord? I can take it. Dusty also, it was mentioned. Grateful. Grateful.
My lords, item 54 is a fresh writ petition challenging the constitutional validity of Rule 4 of the BCI Election Rules 2023 as amended by the October 29 notification. My lords are already seized with the matter. This may be tagged with the main matter, my lords. My lords, just one aspect I would like to highlight, apart from the aspect of pending criminal proceedings. On the aspect of pending disciplinary proceedings, my lords are aware that in service jurisprudence, pendency only begins from the point of, because of that.
Later on.
Yes.
You already issued.
Great.
Lordship, for 54, Senior Advocate Guru Krishna Kumar sir has to appear. Actually, a similar matter has been disposed of for 54, item 54.
Which item, sir?
Item 50. Okay.
Item 56.
Yeah, please, notes. As I'm only asking that the High Court, because predicated offences going on in, that's all I'm seeking, Malazri.
करने के लिए एक बार
अब ये हो गया ना, इसको प्रॉब्लम ये है कि उसको बना दिया गया। एक्सपोजर है नहीं किसी चीज का
सवाल तो भी वाली नहीं है तो हम मुकुल बाबू को बोल रहे हैं सर
The short grievance of the petition that is filed, criminal miscellaneous CRM-M-66193, stroke 2025.
Transfer interstates transfer High Court notice.
How High Court will grant relief to you?
Well, the under 44, the
44, you are right, but interstate transfer is beyond the jurisdiction of the High Court.
Problem from Haryana to Delhi or Delhi
Haryana to Delhi, it can only be by the Supreme Court transfer.
well, under 44, we had only sought a direction be given to the ED to move, because this can be done only by the prosecuting agency. ED can do it. We could not have done our own request. We requested because on a one place the witnesses are accused and the accused are witnesses. It is not going to serve any purpose on any front. And that will delay as well as the prejudice the trial. It's not going to benefit anyone in this.
Because pending हमको order का transfer लगाने that criminal miscellaneous number so filed by him under section 528 of BNSS, that is section 44 of PMLA, has been admitted by Punjab and Haryana High Court. Admitted को single command में करना and order to be heard within 1 year, widely informed order dated January 2026. For her in position by Missionary Counsel for the petitioner. It seems to us that owing to the nature of relief sought by the petitioner, the High Court ought to have decided the petition preferably at motion stage. There was hardly any necessity to admit petition. Be that as it may, the petitioner may move an application before the High Court along with copy of this order. Thereupon, the registry of the High Court is directed, list the application along with main case, final hearing, after obtaining necessary orders from Honorable Chief Justice of the High Court. The bench to whom the case will be entrusted, is requested to make an endeavor, is requested to decide the main case within 3 months. Within 3 months.
Very well, Mr. My statement can be recorded before the CBI court. The next date is on 7th of March. I'll put a request that my matter is under consideration, that I'll ask for, seek an adjournment on that part. Let's see. Before. That's my statement.
No, what is there on 7th March?
CBI trial, which is going on, listed before the CBI court in the Panchkula court, which is listed on 7th of March. I'll request for an adjournment there. And just to make my disclosure from my side, I'll requesting my statement may be recorded to that effect.
It is stated that petitioner will request the CBI court for deferment of trial. We express no opinion in that regard. The said court will will pass, will take an appropriate decision.
Please, Manoj.
In accordance with law.
I'm grateful.
Yes, the NGT on the first day of hearing.
I'm sorry, this is regarding dredging and desilting within the rivers in the state, Malods. Unfortunately, NGT on the first day ex parte has passed an order saying that the state can't do this. In Telangana and Karnataka, the same issues arose. Your lordships were pleased to grant notice and stay. On the first day, this is very, very critical. We have had floods. We need to carry out this desilting. We have been told to strictly do it in terms of the central government's policy. We are doing it strictly in terms of the central government's policy. We now have a situation where even the Bakra Nangal Dam, unfortunately, just this month, we have come to learn that nearly 25% of it is covered with silt, and we have crossed a very dangerous mark there as well. Now, if your lordships were to see the impugned order, which is done without hearing us and not being aware of the fact that there is a PIL which is pending in the High Court of Punjab and Haryana, where a similar interim order was already vacated on 19th of September 2020. Yes.
Mr. Gopal, why don't you bring all these facts to notice of tribunal?
Well, now that the problem is there's grave urgency. This matter is now listed for May, my lords. And this is the grave urgency, yes.
I always seek preponement of date or vacation of stay. Let it be in May, but you can always apply along with a copy of the orders passed by the High Court, where stay was granted and then vacated. And you can show to the tribunal that it's a case of form shopping. Forget about merit. Basically, you are arguing on the point of form shopping.
Yes, but the problem is this. The problem is this, that because it depends on the monsoons and the rains coming, we have to carry out this job on a war footing, which is what we are doing. We're doing it for the public, my lords. In many cases, it's complete expenditure from the state. The state is almost going into losses while they have to carry out each of these exercises.
We understand your problem, but at least because the tribunal doesn't know anything about High Court procedure, the petitioner must not have conveniently disclosed all these things.
No, obviously they did not, my lords. Now, the unfortunate thing is we are stuck with this situation. If I can just hand over those two orders, just please see your lordship's orders, because it's the same. The criticality is in fact much less in Karnataka and Telangana.
No, the point is not the point is that there is a matter pending in tribunal, and the tribunal has passed the order in ignorance of the events that have taken place in High Court.
Yes.
We would like that first you give a chance to the tribunal. If they rectify, it's all right. Otherwise, you can always come to us.
But Manoj, I would need that protection when I go back to the tribunal, because if it's in May, suddenly we are stymied while in the middle of action. When there's a High Court order, Manoj.
The protection is that we will request the tribunal to take up the application immediately and pass an appropriate order within a week.
I think that's fair. We can't ask for more than that. I think that's very fair. We cannot urge you to do anything further.
Yes, my brother has rightly pointed out, para 9 of the tribunal's order.
Yes.
Also, para 10 of the tribunal's order.
Yes.
Right on. The state of Punjab is going to appeal before us against an interlocutory order dated 11th February 2026, passed by the National Green Tribunal, Principal Bench, New Delhi. Why this order from the tribunal has stayed the tender postings, has issued interim direction that though the tender posting will proceed, but the work of desilting will not be commenced without the leave of the tribunal. Next paragraph. This order is challenged in the backdrop that earlier a purported PIL was filed before the High Court, in which ad interim stay against desilting process was obtained. But after the facts were brought to the notice of the High Court, the stay order was vacated on 19th September 2025, though the PIL postings are still pending in the High Court. in a way, comma, it is alleged that there is an attempt of form shopping in order to stall the desilting process by this state. Next paragraph. We have heard lunch in council for the state of Punjab. In view of the liberty granted in para 10 of the impugned order by the tribunal, we are of the view that it seems to us that the appellant state should firstly approach the NGT with seeking one eye preponement of the hearing, two eye vacation and two eye for vacation of stay. The state will be well advised to mention all the facts in its application, including the previous attempt to secure and stay from the High Court in PIL proceeding.
Only before you, they made a
First of it. Point to the urgency in the matter of owing to the nature of urgency for desilting and dredging of rivers, dams, water bodies. We request the NGT to pass an appropriate order on the application, on the state's application, as early as possible and preferably within a week from the date of this filing. Next paragraph. We have a reason to add that we have not expressed any opinion at this stage. Next paragraph. Liberty is granted to the appellant to approach this court again for my so required after passing of orders by the NGT.
Was just one aspect. Because in a lot of places, desilting work was already going on. Because the way the order is framed is that it will not commence. But in a lot of places, desilting work was already going on. My laws may consider that wherever it was going on can continue.
Owing to the urgency of desilting and coupled with the plea taken that desilting exercise was already going on, from then say liberty is granted.
I'm so grateful.
Grateful. Very good.
The contention has been reported that desilting was going on.
Yes, I took 59.
Lord, I appeal for the petition. Serial number 59, I am appealing for the petition.
Yes, please.
Lord, these are the petitioners who had participated in the appointment of JMFC and Lord, the Junior Division Civil Judge, Lord. And Lord, their number 1 and 2 petition was allowed by the High Court. Lord, some other candidates who are aggrieved have come before this court and that order has been stayed. Lordship is hearing that matter that is now due on 11th of March, Lord. But in the meantime, Lord, the order which was in our favor was relied upon by some other counsel in some other proceedings. And the High Court felt that the earlier some facts were not put and now show cause notice has been issued for review of so not. That order is under challenge. Lord, that order is already understood and it's within the domain of this court, Lord. So that matter is coming up on 11th of March. Lordship may take up this matter on 11th of March. But in the meantime, Lord, that should not be recalled because it may be stayed, Lord. That's only request.
So you are saying already stay is there.
Sorry?
Already you are saying stay is there.
Yes, stay is already there, but pending that stay of that order, Lord, the High Court has now issued a show cause notice, Lord, why that order which is Lord, pending in this court, under challenge before this court should not be recalled. That is the order, Lord, on page 1 of this petition. And that main petition is now due for hearing on 11th of March. Lordship may take up this matter on 11th of March along with that petition, Lord. Because the notice is made returnable by the High Court on 24th of March.
March, that will shown. So, meanwhile, the review stand revive.
Yes. Lordships, if I may just assist on one point. The review has been registered suo motu by the High Court.
Meanwhile,
So it may be tagged with the pending matters. I am for the petitioners in the other matters.
Because that is my request. It has to be taxed.
Promoter review petition should be stayed.
meanwhile, slow motor review petition shall be next year.
Grateful man. Obliged.
Lord, inter-se disputes in a company about shareholding going on from 2015 between us. Several complaints filed.
But see your order, Mr.
No, I have never seen an order like this. I have not heard. He says, APP says this, an order is passed. The judge, my lord, should have seen it's a festering commercial dispute between parties, and using this, my lord, they have lodged an FIR the next day, and the FIR records this order.
Mr. Dwarki, if your respondent went to the magistrate and prayed for a direction for FIR, would you have been heard?
But my lord, I may not have been heard in 156, but in,
but
in 226, I have to be heard in the lordship judgment. There's a judgment.
That's the stage of the proceeding.
No, have a look, my lord. There's a judgment, my lord, of this court in a matter which arose from Chandigarh.
No, but why don't you approach the High Court?
You know, now FIR is registered.
Challenge the FIR.
Challenge the
FIR.
This order will come in my way.
No, we clarify that this order will come in.
But my lord, with respect, my lord, this is not the manner in which the High Court will pass a two-line order. APP says this, and therefore it is done. But you are bypassing 156. My lord, as the lordship says, Shakiri Vasu says, you have to first go 156.
Today, the High Court has become the supreme magistrate for the state.
But my lord, this is not the way.
Many petitions come before the High Court. They have to pass reasoned order.
But there are three flaws in this order. One, in a 226, as opposed to 156, my lord, or registering FIR.
We are lucky that they went to 226 and you got a brief. What is there? Challenge the FIR. Challenge the FIR. Challenge the FIR.
My lord, then, you should not grant me protection for 2 weeks. I'll challenge it because only, my lord, this is not fair what has happened. So I should also get some protection, my lord, till I challenge it. You are not heard, nothing, my lord, and is done this question. These are commercial disputes, these are given. A criminal color, my lord, talks about shareholding from 2015.
We understand everything. The thing is, make 528 application, 482 application, anticipatory bail, questioning all prayers before
The
the
lordships feel I will challenge it, my lord, preserve my rights and give me protection for a week or 10 days, my lord, I'll challenge it.
The petition grievance is against the order dated 12th February 2026. Passed by Iran, single judge of the High Court of Gujarat. The order has been passed after recording statement of the Assistant Public Prosecutor that an application received from the petitioner before the High Court will be taken into consideration while registering the FIR. That complaint was against the petitioner. We are informed during the course of hearing that FIR has already been registered. And our concerned view from the appropriate recourse for the petitioner at this stage would be to seek questioning of the FIR before the High Court, taking all such pleas which have been covered before us in this petition. It is clarified that if the petitioner adopts such reports from an implement order dated 12th February 2026. Passed in special criminal application in bracket direction number 2024 of 2026 shall not cause any impediment against entertaining this petition shall cause against the petitioner for approaching the High Court. Such a petition shall be decided as per its own merits. Against the petitioner for the purpose of grant of interim or final relief. Such a petition shall be decided as per its own merits.
But I am praying for no coercive steps for a week or 10 days to give.
That applies before the High Court. That's why we have said that interim relief also open.
I will apply, but Lord, I should not be arrested tomorrow the way it is going.
Impossible.
No, they are in the house.
Lord, they are now settling.
They are in all offices. The children are being, Lord.
The state has not acted from 22 to.
But now they are acting.
Now this handle, now there is a handle to act, and within 2 days an FIR is registered. This complaint is on 27th January, you move the High Court, you get an order.
For 3, 2020.
It is not. Because disputes are going on from last 15 years.
For 3 years, I went.
The idea is, Lord, your Lordship knows what the idea is behind these kind of things. In a town to show, my Lord, that between this man, he has gone to jail or not jail. I am only requesting, my Lord, an order of no coercive steps for a week to enable me to move the High Court.
No, the Honorable High Court will consider that in my humble submission.
But what is this great happening, my Lord? After 15 years?
I can only say this. As a complainant, for 3 years, I have gone pillar to post. Today, there is a forensic report against them. There are documents against them. All of this has to be considered. Let the Honorable High Court consider.
I respectfully submit that what has happened is not fair. And I request, my Lord, that I should have some protection.
No, propose the High Court. Yeah. That is directed that no coercive action shall be taken for a period of 2 weeks. For a period of 2 weeks.
Grateful. You find it now.
This interim relief shall have no bearing on the grant of interim or final relief by the High Court.
I am obliged.
Lord Dusty may be. Please. Grateful.
Yes, my lords, by the last order had asked the CBI, this is the Manipur matter, my lords. My lords had asked for the CBI to file a status report in all the 11 cases that were handed over, 11 plus some more, handed over for investigation.
Lordships, I'm appearing for the committee.
That has been filed.
Rehabilitation side, your Lordships. Because there's some
Status report has been filed. The 12th
highlight.
CBI has been filing periodic status report. 12th report has been filed. In field cover, that's all. Because
we have not been able to see honestly speaking that.
But your Lordship, yeah.
Suggestion.
But since the Guwahati High Court will now monitor the cases which are undergoing trial in Guwahati, let it continue. Why should these matters remain here?
So last time we were suggesting that if
my lords,
if Manipur probably you have some reservation.
Guwahati will get it.
Lords, just 2 things. The CBI was to apprise both the victim families and the court and share a copy of the status report. We continue to remain in the dark despite the order of this court. We don't know what is happening. What we do know is that in rape trials, the accused is being dealt with very casually. We don't even know if they are the main accused. We can only see the order sheets which are uploaded by the trial court. My lords, let that CBI status report become available. It has been shared with us in the past.
Shared with us, shared with the victim, I can understand.
All we are asking is a status.
Why?
Accused, arrested, charged. These are statutory rights. I'm not asking anything beyond what is my statutory right. Why can I, the victim family, not know what is the fate from 2023 to 2026? This is what the law says I have a right to.
All the accused have been given whatever has to be given under section
But
133.
we don't know. We don't know because nobody has told us.
Lordships, even on the
accused knows,
rehabilitation side, this is
the victim has a right, a statutory right, a constitutional right to know. This is being prosecuted on my behalf.
What is the legal position about victims or their families?
Victim, all those relatives concerned, they've all been given protection as far as protection is concerned.
No.
Who are the
Victims
accused?
have been rehabilitated.
Yes,
We've interacted with them.
But are they not entitled to a report? What is the legal position? Because that language used was very guarded about state now that victim can also engage counsel, join proceedings. There is very guarded language used. What is the new language expression in the new act?
They have been given BNSS.
Let us first we go through. We will first, now that they say, because we haven't seen that any report has come.
Both under BNSS as well as under the SC/ST Prevention of Atrocities Act. In fact, the Atrocities Act has a very detailed plan how the victim is to be supported, including by being informed. There is a statutory mandate. And my lords, why should I
The
know
victim's brother,
what is happening in the case? Do I not, as a parent who has lost my daughter in a sexual assault and murder, I cannot know. I am not going to travel to Guwahati. Who will inform me? Is it not the duty of the state? And is a mere rehabilitation? I have now left the relief camp.
These trials are now in Manipur or in
both.
Guwahati, Lordship.
Some cases were
The 11th
Guwahati.
11
Some
under
11
Guwahati by an order of this honorable court.
And as far as Guwahati is concerned, CBI has commenced the trial. Wherever charge sheets have been filed.
That is what we wish to know.
Charge sheet copy has been given to
Lordship,
brother.
Lordship,
One young woman has died.
there are a lot of organizations who want to put their hands in everything here.
Others alive.
Do you have any counsel to represent you there in Guwahati in proceeding, trial court proceeding?
No, my lords, they don't have anyone.
Lordship, if I may submit, Lordship. Lordship, I appear in Miss X versus State of Manipur, which is the matter of the video which went viral and my lords had taken sumo to cognizance. I appear for those victims. Lordship, so the status there insofar as this trial is concerned, it's going on in Guwahati. Lordships had on 25th August passed a detailed order for pre-trial procedures, etc., how the appearances, etc., are to be taken. For post-trial, Lordship, there was no detailed order passed. So, Lordship, that is one thing that I wish to point out. Because now the question of examination and cross-examination is there. Witnesses don't want to travel, and there is an order of the special court recording that the witnesses don't feel safe to travel.
Do we have Mr. Dattatreya here today? Mr. Dattatreya, the former
required to monitor.
That's right.
Also filed.
That's right. Lordship. He was appointed to monitor.
There can be two way outs that because they need to have representation in the trial proceeding.
True, my lords.
Please don't think that only by providing representation here the purpose will be served.
Yes.
A true exercise will be in trial court.
I bow down, my lords, that is true. There will be a public prosecutor who will act on the charge sheet. I do not know what is in the charge sheet.
Now that
my right to file a protest petition, how will it arise unless I have
not protest petition alone. Now the law permits you to join proceedings along with the public prosecutor.
Yes.
Along with the public prosecutor.
But all that I will need some status. I do not know anything.
Lordship, just to indicate, Lordship,
who is the I?
It is. We are not asking for anything more.
For status, we will not even depend upon this CBI because there is an independent arbiter appointed by this court, a former Director General.
Please, my lord.
He has filed a report pointing out. He said that. He gives the full details where the SITs have been constituted in 8 districts, what kind of offences are being investigated, and about the charge sheets filed. Say, for example, we say out of 31 cases, say SIT were constituted in 36 matters. Out of that, then 31 cases, charge sheets have been filed in 20. 5 FIRs they have been filed. Filed means untraceable. And the investigation pending 6 cases will be completed in 6 months. This is the status filed by an independent person appointed by this court.
My lord, but we don't know which ones. The CBI was handed over certain cases. The SIT is dealing with other cases.
These are
not only the SCI
He is the person who has been appointed by this court to monitor even the CBI investigation. That's why he says he has filed the status report regarding the investigations of the CBI and the Manipur police both. SITs in view of the order dated 7th August 23. Please see the order of 7th August 23.
My lords is right. 7th August is a very detailed order with detailed directions. So, my lords, therefore, what has happened thereafter? I am living in a remote part of Manipur. I am not traveling either to Guwahati or to Imphal. In fact, I can only speak from what is available in the public domain. There were new ministers sworn in, including 2 deputy CMs, to build confidence from different communities. The deputy CM from this community did not travel to Imphal to take oath. This is a matter of record. It was published in national media. Surely the victim family has a right to know. There is enough jurisprudence in this country to show that a victim family of rape and murder has a right to know.
I'm so sorry. You talk from public information, information to the country, eminent travel.
Because the legal aid committee.
Please don't stand by unverified information.
All right, let us do like this.
So we may be given the reports, please. These reports of the DGP may kindly be given. I accept that he is an independent person, but I have not got his reports now for 2 years.
Only status. What has happened?
We don't have those reports, so we are a little disabled in arguing before your lordship.
My lord,
in this batch of cases which are
With the articles you can share.
Yes, that is what we are thinking, but not
arisen out after the unfortunate.
But not with this organization. They are represented by organizations. They are represented.
Acts of violence and series of heinous offences that took place in the state of Manipur. So various orders have been passed by this court from time to time, inter alia, for the purpose of 1I, entrusting investigation of some of the cases to CBI, 2I, constituting SIT in some other cases where Manipur police have been investigating those, where the Manipur police is the investigating agency. Not only the 2I, Mr. Directorate, Parishali Garikar, the former Director General of Police Maharashtra, was appointed on 7th August 2023 for the purpose of exact word order as well, monitoring and supervision of the investigation by CBI and the Manipur Police. Next. The committee, headed by a former Chief Justice of the High Court, was also constituted, whom the responsibility of rehabilitation and to recommend the measures for ensuring the medical stroke psychological care from a dignity and relief camps and compensation stroke restitution, including monitoring the compensation to be released through NALSA stroke SALSA. Former Director, to ensure fair and time-bound investigation, this court had appointed Mr. Directorate, former Director General of Police of Maharashtra, to supervise CBI plus state investigations he was further authorized to take officers on deputation, outside officers on deputation, for the purpose of constituting SITs to visit relief camps and follow sexual offence safeguards, besides various other responsibilities. Next paragraph. In furtherance of the assignment given, Mr. Dattatreya Prasigalkar has filed 12th status report dated 18th February 2026. According to this report, 36 SITs were constituted by the government of Manipur in 8 districts to probe serious offences and riot cases. Simultaneously, 31 cases of heinous crime were transferred to CBI for investigation. Out of these 31 cases, charge sheets have been filed in 20, 5 FIRs have been filed in record, that is cancelled, and the investigation in remaining 6 cases is still pending, which shall be completed in 6 months. Next paragraph. We are informed that the trials were transferred out of the state of Manipur pursuant to the orders of this court, and at present all the trial proceedings are pending at Guwahati in the state of Assam. So,
CBI trials.
as is disclosed by Mr. Dattatreya Prasigalkar, out of 31 cases entrusted to it, CBI has already filed charge sheets in 20 cases. It seems to us that the victims' families are entitled to copies of the charge sheets filed in their respective cases. As it appears from the submission made on their behalf before us, the victim or their families are not even aware of filing of the charge sheets, for the simple reason that while they are still staying in state of Manipur, the trials have been, the judicial proceedings have been transferred to the court at Guwahati in the state of Assam. With a view to facilitate participation of the victims or their family members in the trial proceedings, where the charge sheets have already been filed, we issue the following direction. The Manipur State Legal Civil Authority Assam State Legal Civil Authority are directed to provide legal aid counsel, one legal aid counsel to each family of the victim, or to the victim or to each victim or their family. First of all, it will be appreciated if it is highly desirable that the legal aid counsel understand the local language stroke dialect of the victim or their families and is in a position to communicate with them. The legal aid counsels, if appointed from the state of Manipur, shall be entitled to travelling and boarding expenses in addition to the fee prescribed under the free legal aid rules. Similarly, the victim or their family shall also be entitled to travel and personally participate in the trial proceedings in Guwahati. For this purpose, we direct the member secretary shall be supplied, the court shall supply in conformity with section 193 in bracket simple 3 in bracket H in bracket again Roman 2I of the BNSS of BNSS. He will be entitled to travel to Guwahati. Their transportation, their travelling and boarding expenses shall be initially incurred by the Manipur State Legal Service Authority, and in case the adequate funds are not available with that authority, we request the National Legal Service Authority to allocate additional funds out of the legal aid corpus and expenditure incurred on travelling and boarding of the victim or their family members, one family member, shall be deemed to be an expenditure incurred on legal aid. Incurred on legal aid. Next paragraph. The legal aid counsel representing the victim or their families shall be entitled to assist the trial court through the public prosecutor or independently as the situation may require. As per the prevailing situation. As per the prevailing situation. Next paragraph. Since we have not expressed any opinion, since we have not gone through the contents of the charge sheets already filed, and in any case, we don't intend to express any opinion concerning the merits of the cases investigated so far by CBI, the victim or their family shall be at liberty to raise all the contentions before the special judge at Guwahati. The special judge at Guwahati. Next paragraph. The Central Bureau of Investigation is directed to ensure that the pending investigation of 6 cases Mr. Dattatreya Padshilkar is requested to ensure that the SIT or CBI complete their investigation within the stipulated period. Stipulated period, please stop. In the event of filing of charge sheet in those cases also, the same recourse as directed above shall be followed. Shall be followed. Next paragraph. Main paragraph. We are informed by the Learned Attorney General for India informs that as per the that the CBI has filed its progress report in a sealed cover, that has been filed in a sealed cover. The registry directed to produce that sealed cover to enable us to go through the contents of those reports enable us to take, to enable us to go through those reports. No, meanwhile, meanwhile, verification. Now, this is the arrangement we are making for the trial court.
Lordship, one more request.
You are dealing with the trial court.
Lordship, I am representing victims in the trial of which cognizance had been taken. Lordship, just 2 points on the order that Lordships have passed. Lordships have said that they will be entitled to travel. Lordship, it may be clarified because currently orders have been passed allowing for their statements to be recorded through virtual conferencing. So that it should not appear as if they are now supposed to travel. So that Lordship may be careful.
The trial court.
I'm just.
Liberty. It is recommended, it is recommended that the statements of the victims or their families may be recorded virtually instead of asking them to travel all the way to Guwahati for the purpose of deposition.
Lordship, and one other thing, Lordship, one small housekeeping issue. Lordship, currently the circular under which was issued by the High Court said that interpreters will be appointed from the jurisdiction of the Guwahati High Court. Therefore, currently interpreters are having to travel up and down because it's just that they are stuck with this. Yes. Lordship may just clarify because interpreters are required to be present when statements are recorded.
That's why what the order bypassed. The legal aid counsel who understand the local language and dialect.
Lordship will remain present.
In between an interpreter and the person, there remains a gap. So it should be direct communication. And it's a question of trust and confidence in a lawyer. Therefore, he will the one who will speak their language. They will adaptability will on a better.
Who will be present with them, Lordship, when the statements are recorded over VC? Because the counsel may be in court, Lordship. I'm just thinking to clarify. The legal aid counsel may be present in court to assist the PP. The interpreter will be with the victim when the statement is being read.
To video conference.
That may not be a replacement, Lordship. That may be in addition.
They will need the legal aid and the interpreter.
Interpreter from their district, so that it can be locally be.
Because it could be a dialect.
We have already issued comprehensive direction that should be sufficient. These orders from the Supreme Court. For the Supreme Court,
my lord, my lords, we are very grateful the charge sheets, etc., will be supplied. We are not asking for full details, but just a tabular form. FIRs, what has happened pursuant to those 11, those status reports are reproduced in these orders which my lords have just perused. What is the status in those?
We will take a call on that.
Please,
one small.
My lord,
why you have mentioned all this?
My lord,
20 charge sheets have been filed.
Please, my lord.
You never know next 2-3 months the remaining 6 are also filed.
Please, my lord.
Now, if the contents of the reports filed before us cause some prejudice to the charge, or there is something which runs contrary to charge,
please, my lord.
It may create problem. It can be a very strong weapon in the hands of the accused. Yes. It can also dismantle the case of the victim.
My lord, that
so one has to be, you see, sometimes our problem is, at least I always think the other side immediately.
No, my lords, that is why we were asking, because so that now that the trials have commenced, we need to know, so that we can accordingly take measures.
Let us, we'll examine it. We'll first see that these reports do not impact the trial in any way.
Please, my lords.
That is the first, I think, foremost. In a case where charge sheet has been filed, that means CBI has prima facie found something. And that prima facie finding should not be tinkered with by any.
My lords, may I just submit once, where is this apprehension coming from? I have been able to access in one case the trial court records. The people there are 2 people arrested. They have not been arrested under the charge of rape. The cognizance is not taken under rape. The charge has not been framed under rape. They are part of the other aspects. Therefore, for us to know what is in the charge sheet, so that at the stage of trial, intervention can be made.
Arrest and charge sheet are 2 different things. Charges will be framed by the trial court. So somebody will have to really put up that call.
That is where the victim will have to come forward.
Done by the now counsel, by the defense counsel.
With
by the victim's
legal aid counsels.
By the public prosecutor or the victim's counsel.
My lord, it appears the prosecutor, this is a special court, the prosecutor has not taken any objection to the manner in which the matter has proceeded.
If you
That is
remember
why there was some
24 If you remember
concern.
24(8), when it was amended,
Yes, my lord.
24(8,
My lord is
the
right.
language was very guarded.
Yes.
Meant was that you will go and you will assist the public
Assist
prosecutor.
the prosecutor.
But in the Tata Finance, while speaking on behalf of the full bench, I interpreted it otherwise. I gave full right to the victim.
Yes.
That it cannot be that you allow him to enter the courtroom and then you say you are silent spectator.
Yes.
This is not the object of the process. So we interpreted that yes, you will have a right to have active participation. See the word I used in that active participation. Fortunately, subsequently, that view was finally approved by this court. So now we hope
The
that we will
timeline
follow.
for the charge sheets to be shared with the.
You have said
There's a time frame.
charge sheet will have to supply.
I'm only asking there's a time frame because the CBI seems to have many, whether within a certain time.
Directly the trial court, we are not asking CBI. That is the duty of the trial court. So therefore, we have directed the court.
I think that's a
My lord,
that's a
my lord.
I have one small request, Lord. Both Gita Mittal committee's time has been extended, Your Lordship. Justice Gita Mittal's term has been extended by the court. And then Mr. Dattatreya, a number of reports have been given. They have not been so far remunerated. I think that issue has been. So I would suggest.
These reports will be simply telling, these were the total FIR, this much we have investigated, charge sheet has been filed, this so-and-so FIR, we did not find anything, therefore we have.
That I will do. I'm talking about the remuneration to both Justice Gita Mittal committee and the CBI.
Why this strictly job has been left?
I didn't want to put it on your Lordship's laps.
Last year,
I had instructed the state of Manipur to take charge of that.
working for it and nobody thought of you.
Yeah, I know. Somehow they've done lot of good work.
What should be there?
Both, I think, the central government and the state of Manipur should share the remuneration, should go properly to both the committee, Gita Mittal committee, and Mr. Dattatreya, who is heading the CBI investigation team, so I can persuade the
We
government.
hope that traveling and boarding, etc., those are taken care.
No.
Or even that is also being.
Has been working completely pro bono since appointment. And
I think she should be taken care of.
You are there for them. You have been representing them, madam?
Yes, sir.
So please find out that how much expenses my sisters have already incurred. They will be cursing, not, of course they are doing such a.
Committee has kept any kind of a record because they've been committed, they've been traveling on Sundays, holidays, as and when, and they've been interacting virtually, physically.
So all that government should cover, there's no doubt about that.
My lord,
I am not very clear, but I can find out. But there are two things I wanted to bring to Lordship's attention.
And who else is there?
Lordship's other members.
There are two other judges.
Asha Menon, and the other is Justice Shalini Phansalkar Joshi from Bombay, Your Lordship's retired judge from Bombay.
It's in the 7th August order.
Your Lordship, it's in the 7th August order.
It has, at this stage, it is pointed out by Learned Attorney General for India that no remuneration, so honorarium has been fixed for the
Lordships have handed over the
three-member committee constituted by this court-wide order dated 7th August 2023. The three-member committee comprises Justice Geeta Mittal, former Chief Justice of the High Court of Jammu and Kashmir, Justice Shalini Phansalkar Joshi, former Judge of the High Court of Bombay, and Justice Asha Menon, former Judge of the High Court of Delhi. We are equally disappointed to know that no reimbursement towards their traveling and boarding boarding expenditure has also been made so far. While requesting proof by Vibhu Dattal and senior counsel as to how much expenditure has already been incurred on the travelling and lodging, we deem it appropriate to direct as an interim measure to release a sum of rupees 12 lakh to Justice Gita Mittal and rupees 10 lakh each to Justice Shalini Joshi and Asha Menon towards estimated expenditure incurred so far or likely to be incurred in future towards travelling and boarding and lodging. As far as the honorarium is concerned, we will fix it separate.
Very well.
My lord,
Same would apply.
my lord, I appear in.
Same would apply to Mr. Dattatreya.
My lord, I appear in item number 38.
Just a minute. As of now, the aforesaid amount will be released by Union of India. So we will later on, it will be a portion between.
That's all right.
The state of Manipur.
I suppose the same will apply to Mr. Dattatreya also. He has been heading the investigation.
Oh, that's
and he was invited by the court to do the investigation.
Similarly, a sum of this 10 lakh we also released to Sri Dattatreya, the former Director General of Police,
Very well.
State of Maharashtra. Then suppose this matter for further consideration
In some cases.
on so and so day.
My lord,
Pending investigation.
my lord, I appear in item number 38.10, my lord.
Just 1 minute.
Yes.
1 minute.
We agreed now, other than that, uske baad karte hain.
Your lordships will notice that those
Reports which the committee would require, your lordships looking into it with regard to rehabilitation, with regard to the housing.
We'll see on the carry.
your lordships also will notice that other than the transferred cases transferred to Guwahati, other matters are pending in Manipur. They're being investigated. Therefore, this will apply only to cases transferred to Guwahati. Other CBI cases.
We personally feel the problem is that unless the victims will agree, we will not be able to do it. All cases should go to one court.
May not. I'll come back on that question. Let's not.
My lord, I appear in item number 38.10. It's regarding the, my lord, I appear in item number 38.10, my lord.
We will see later on. Not all the matters to be taken up today.
Yes, my lord, I'm requesting that I may be allowed to withdraw with liberty to approach the jurisdictional high court, my lord. I'm praying with liberty to withdraw and file a fresh petition before the jurisdictional high court.
So we have granted liberty to join the proceeding.
Item number 38.10. 38.10, Zamgai Kim Gangte. It's regarding a case where a mother and son had been lynched by the mob and killed. I may be allowed to withdraw and file a fresh petition before the jurisdictional high court. I may be allowed to withdraw the petition and file a fresh petition before the jurisdictional high court. Item number 38.10.
Seeking liberty to withdraw to go to jurisdictional high court.
All right, petition so and so dismiss or withdrawn with liberty to approach the jurisdictional high court.
Obliged.
I have prepared a snapshot of the work which is already done. Instead of your lordships going through all the reports, I'm just handing it over. Lordships, this is an easy read which I have provided. We've rehabilitated 7,000 houses, etc. If your lordship goes through it, lordships will see how the committee has acted as a bridge between the people and the government, your lordships. And all issues including education, rehabilitation, housing.
It's all right. Nobody is disputing that they have done a commendable job.
That's a snapshot.
Can we have a copy of this, sir?
My lord?
We don't have a copy of any report.
Yes, will be.
This I can hand over.
Anytime, when your lordships decide, we'd like
My
to have
lord,
a copy.
in item number 38.14, my lord, this matter has become infructuous as the alleged encroachers who were
He wants to withdraw.
using the school.
We also want the same order.
Yes, madam.
You want to withdraw.
Kind of order that you want
The
to
matter has become infructuous.
Become infructuous.
It will become infructuous. All right, infructuous.
38.14.
All right, then we will take up the remaining issue. Will take up on the third
Very grateful, my lord. Grateful, your lordship.
Item 39.
Item 39, my lord. I seek some accommodation, my lord, on the ground that Mr. Mehta is leading me and he is before a special bench in a overnight part heard, my lords. I just see.
Otherwise, are they now safe and are they in a safe condition now or?
The people who came back are in safe condition, but there's another family which is across the border, similarly situated, and my husband is still across the border. All that the High Court has said is bring them back, then
So
go.
maybe that now with improved condition, they have a choice to stay on this side of the border or this side of the border. Now with the improving conditions, hopefully, they might think of choice. If there can be a choice, they might.
My lord, we are Indian.
Eh?
We are Indian. We want to stay this side of the border.
Very good.
That's the. And
Every Indian citizen has a right to stay here. There is no doubt about it. But it's all.
We were thrown out in 2 days. Now we have given our document also to the Solicitor General. And we've given it in
He
December.
said he would take instructions, you remember?
Yes. He
is saying that it's a little more time if they are verifying.
Please. If it can be kept on the reopening, because this we are stuck.
How the state machinery is busy in West Bengal, Mr. Sibal knows when he comes on this side.
No, as far as I am not involved in politics, I just want to come home.
No,
That's
no
the
politics.
problem.
There is no politics. It's all the election machinery, the state machinery. How are they busy?
Please, Madam, here it is the center which pushed them out. Just let them come home. Let them even stay in a specified area with reporting daily to whichever police station. But let them come this side of the border. That's my plea, my lord. It's after all, the other family is a woman and
instructions. Verification part. Complete it immediately. Now.
Please, my lord, kindly have it after the vacation, my lord.
Immediate of opening week, first week of opening.
Please, my lord.
Next.
Grateful, man.
I know.
Last time your lordships had directed me to file a comprehensive note, but that note has been circulated to your lordships. Your lordships had directed me, this is that definition of Aravali's plus, item 40. Your lordships had directed me to file a comprehensive note, submit a note, that note I have circulated to your lordship.
Have you sent it?
Yes, please. Very good.
Oh, that's it. That's it. You can give this note to the all of them. So then we'll be able to have a better understanding.
I have an IA, where I have a mining lease. I have all permissions.
Nothing, not all permission, no permission, no will not permission.
I have stopped because of the lordship's order. I have been stopped. I got the mining lease after 10 years of litigation.
Rightly stopped.
First they said I am not in Aravali. Then they said you might be. I am taking a position that I might be. I don't.
Now it will be free for all to say I am not in Aravali because.
No, I am not saying that.
Unfortunately, nobody knows what is Aravali.
Correct. So, I am not taking that stand. I have not.
Go by. It's not that mining.
I have closed, my lord.
If a lawful mining, probably on the very first day, eventually the lawful mining we will permit.
That is my case.
We need the construction material also. People need it because we can't stall everything.
Order said lawful will start.
But first, the entire exercise has to be completed. Identification of what is actually around.
No problem.
1, 2. Let the subject experts tell us first principle, mining permissible or not. Can the mining be allowed at all? Yes, if they say it can be allowed, up to what conditions? Then who will monitor those conditions? All these one by one these stages will come. It will take little time, but we will cross all bridges and we will reach the right destination. Mr. Chima, you also keep on writing articles on this. Why don't you also assist us?
Happy to take part.
Released your book, one of the book on environmental issues. Mr. Parmeshwar is already there, but you also assist and help us. This is not a kind of adversarial litigation. We thought that all, as a domain expert, you can help, being member of the bar also. On 21st January 2026, Mr. K. Parmeshwar, Senior Advocate and amicus curiae, besides other learned senior counsel, strong counsel appearing in the matter, were requested to submit a comprehensive note along with the proposed questions that are likely to arise for consideration in these postings. In reference thereto, Mr. Parmeshwar has circulated a self-speaking detailed note. Let soft copy thereof be also circulated amongst senior counsels to counsels for the parties, as well as those who wishes to assist this court as interveners. In this regard, we have also requested Mr. Jayachima, advocate, who is known as domain expert, to provide his assistance to the court. The counsel to the parties shall be at liberty are granted further time to submit their respective notes if any by 10th of March 2026. We do not propose to extend further time beyond that, as it will unnecessarily delay the proceedings. Next paragraph. The opinion of the Ministry of Forest and Environment shall have a direct bearing, shall be of eminent assistance for us to for the purpose of A, defining the expression orally, B, its total area, C, the radians and hillocks, etc. 4, the forest cover. 5, the part of the Aravali already utilized for the cities, towns and villages which have been developed for centuries. If you will go by the original history, the Supreme Court building, this building is also in Aravali. So many other buildings will also, if you go by the old history.
It starts from the Rashtrapati Bhavan.
Because
Starts from that. That's the top.
you will find so many cities.
Hills is part of Aravali.
Entire Jaipur city, entire Jodhpur city, entire maybe Kota and all these things may be in Aravali. But today to say that it is Aravali may not be, it will be a misnomer. So those areas which have been centuries developed.
Water supply comes.
That's right. Similarly, we request the ministry to suggest a panel of the domain experts along with their profile. In this regard, Leonard Michael, Mr. Jayachima, and other learned senior counsels to counsels are also requested to give the profiles of some eminent subject experts.
There are some names.
Eminent subject experts for the purpose of constituting the committee as was observed by this court on the very first day, that is 29th December 2025. We are conscious of the fact that all activities, including especially mining activities, for which license, stock lease, etc. were granted, or necessary permissions were also granted by the authorities, have come to a halt. However, the such status quo will have to be maintained for the time being till some of the preliminary issues are effectively answered in phased manner after constitution of the committee. Post this matter on so-and-so date at 2 p.m. for the purpose of constitution of the committee and formulation of the issues that will arise for determination. The necessary material, including notes, if any, in the opening week, we'll keep maybe a miscellaneous day. Content. Not only 2 p.m. It in the opening week of this 9th March, maybe 11th, maybe 10th, 11th, 12th, and one date out of this. So this
Very senior. Right. Right.
Grateful, Madam.
Lord, I was asked to take instructions, Lord. In this case, I was asked to take instructions.
Item 43.
Yes, Lord.
Yes.
Your Lordships, this is a transfer petition that has been filed by me, the founder and director of an NGO that works for acid attack survivors. Now, herein the victim is a 17-year-old girl who has been brutally attacked by her own father. The details of the attack have been mentioned on page number 4, para 1 and 2. Your Lordships, I would like you to go to the page number 22nd to 25, wherein the photos of the victim are...
Just a minute. What are your instructions?
In this case, challan was filed on 27th of October 2025. Then thereafter, charge was framed on 4th of November 2025. There was 26 witnesses. 8 witnesses have been examined. The next date is now 9th of March.
No, that is not the instruction.
Yes, Lord.
We need instructions why this trial will not transfer.
Lord, so far, there are allegations that she is getting some threat. Lord, we have not received any complaint with regard to threat, my Lord, nor we have any information.
Your Lordships, the victim is getting a regular phone call from the...
Unfortunately, my Lord, accused in this case is the father of the victim, my Lord. Unfortunately, my Lord, the accused in this case is father of the... But we are, my lord, we have filed, after, my lord, completing the investigation, we have filed the, my lord, final report, and thereafter charge has been framed, trial is going on.
Your Lordship, few points I would like to mention which are very important to highlight. One, that sees 17-year-old.
Like just the hard learned counsel for the petitioner as well as learned senior additional advocate general on behalf of the state of Haryana. Anyone appearing for the Satyavan? What is the report?
Your Lordships, on page 26, there is a note by the Director General, Plastic Surgeon of BLK Max Hospital, Dr. Bath, who mentions that the treatment will go on for 1.5 years and there needs to be continuous consultation in the hospital. Her treatment is going on in New Delhi. There is constant threats.
This transfer petition has been filed by a victim. Has been filed by an NGO seeking transfer of trial proceedings in Cecil trial number 5794 of 2025 in bracket State versus Satyavan, arising out of FIR number 383/2025 under section 124 in bracket 1 BNS 2023. The above stated trial is pending in the court of additional district and sessions at Bhiwani. The allegations are against the father of the victim, who allegedly poured acid on her while she was asleep on 3rd August 2025, followed by multiple attempts to kill her. The victim has no surviving. Where is mother?
She's dead. It's been 14 years since she has died. Just one minor brother.
The victim has been mother earlier died. She has no, her father being himself accused, the victim has no one in the family to support. There's no guardian in one. She is getting multiple, on account of the multiple reconstructive surgeries and continuous medical treatment in New Delhi. The victim appears to be not in a position to effectively participate in the trial pending at Bhiwani. As per notice was issued, and as per the office report, correspondent to
Interim transfer करने से प्रश्न interim
Respondent 2 is still awaited. Then say, yes, so which police station this incident?
This police.
Bhiwani Sadar.
Bhiwani, my lord. Sadar Bhiwani, my lord.
Police station Sadar Bhiwani is directed to effect service on respondent 2. And send a report to this court that the said respondent has been duly informed about pendency of these proceedings. List on opening 9th
In fact, he is confined in jail, my lord. The address has been given of his village, so therefore he will not serve. He will serve, my lord, in the jail.
He is in jail where?
Bhiwani.
Through the superintendent of Central Jail, Bhiwani. Informs one.
District jail, Bhiwani.
Just to go. Inform the state that we will do so. Finish the matter on 9th March. State to continue. One of the
Related matters also the 91.
concern about risk number 2 only. One is state is appealing.
In the matter, I think subject matter would be different. This is only for.
This will be separate.
This is a subject.
That he is judicial.
Clean, my lord.
On 9th March, then we will take a plea.
Clean.
Great.
One second.
Is a lordship.
No other matter will be taken.
May not. When will it, yeah.
इतने मैटर जंबल करोगे तो ऐसे होगा.
The lordships can squeeze it before the constitution benches start.
Before 17th.
The lordships can squeeze it before the constitution benches start. One sentence I want to say is, I am the only person who's not a private party. I am the state of Telangana, whose irrigation projects only for expansion are pending because of this. So I'm not for a private party. Where
No, I'm releasing some of the matters from my roster. I'm sending.
no, this is Vanashakti.
One Shakti, my lord, I was on.
Because Vanashakti.
Vanashakti we are taking.
So that.
I was on my legs, my lord, I have to continue the.
I'm only on one shot. No,
I was on my legs, my lord, lordship said. So whenever your lordships feel, my lord, convenient to.
Before
17th, it can be, because then constitution bench is sitting.
No, we'll have to hear before that.
10th week or whatever.
That's
week
what-
of 10th.
That's what I'm saying earlier.
Perhaps on the 11th, my lord.
10th, 11th was 11th week. 11th.
10th there is a problem there. 11th we can.
11th. 11th is all right.
10th is a Monday.
No, 11th.
10th is Monday.
No, 10th is two.
We can take a chance on 11th if it suits.
11th, my lord, if possible.
Not 11th, 9th को 2 PM को रखा है. 9th को 2 PM को रखा है.
No, it's all right, 2 p.m.
So that week only keep not more than 25 matters in the morning.
Ninth, my lord,
Obliged.
at 2 p.m.
At 2 PM.
Deeply obliged.
Good.
Obliged.
Can we take just for half an hour?
Okay.
My lord, may I request 301.3?
My lord, before your lordship takes up 301, can I make a general thing? Because my question 302. So if your lordship permits me, I just want to make a brief point.
We have only 20 minutes. So,
I know, I'll take only, I'll take only 2 minutes.
302 minutes.
My lord, I'll only take 2 minutes. My lord,
first we will give time to you.
Yes, but since your lordships have less time. My lord, the issue here in both 301 and 302 is in respect of the 3-year, my lord, qualifying service before, my lord, the person can take the examination.
My lord, my request is 301.3. Just a minute.
So, my lord, 301 are essentially a batch of writ petitions. My lord, certain people have said there were difficulties on various accounts, my lord, I will not go into that today. And then there are some review petitions. And the other, my lord, 302 also has some modification applications. People who are doing LLMs, for instance, want one modification, someone wants another modification. So, your lordships in the last order had said that let the high courts give their, because the earlier order was passed on the basis of what the high courts wanted very largely. Except 3 high courts, every high court wanted this, my lord, the requirement of, my lord, this practice.
Again, that
Absolutely right. So, my lord, now, since I did not have the documents in the first matter, but I still very quickly went through some of them. Some high courts still are very, very firm about the fact that they want a practice requirement. Whatever I have read, some of them. I have not gone through all of them. If your lordship permits me, I'll take all of them, put them in a compilation.
We will do that.
Yes.
We will do that.
So that your lordships can take a holistic view, as your lordships have yourself said in this order. So that's what my submission was. High court's view plus NLU's, etc. view.
prepare a compilation.
Please. My lord, can I just make one suggestion for everyone here? My lord, as per your lordship's order of 15th January 26, your lordships at para 3 observed as follows, that prima facie eligibility condition must be uniform. So that should be, my lord, in with my respectful submission, the focus of the argument before your lordships at this stage, because it's not that we are reopening the whole thing. Yes.
Uniform also
And holistic.
to read the pulse of the
Correct.
NLU students
Yes, my lord.
from the country.
My lord, actually only 2 NLUs have responded. I wish some more would also.
To say, my lords, and what my friend is saying, my lords, and what we are insisting, my lords, on your lordships considering the following, my lords. One, my lords, is not only what the high courts may have expressed, because there is extreme divergence even amongst what the high courts have expressed. With due respect to, my lords, the views of the high court. Thus, some kind of objective criteria is needed, my lords, for this purpose. Not only the desire, but, my lords, also the need. Secondly, my lords, your lordship is constantly, my lords, encouraging the judicial academies, my lords, which are undergoing these training processes and have been set up, my lords, partly for this process of training itself at all levels, my lords, then to encourage, my lords, yet another tier, my lords, to actually stagger the difference between the entry levels and the promotional levels. Because you are going to discourage, my lords, a number of people. Because by the time they will achieve, after, my lords, adding in these years of training as a necessary prerequisite, it will go from 27, my lords, roughly at the entry level, with the 3 years training, to 41 to the next level, my lords, which will discourage not only people and youngsters, my lords, from going into this field, my lords, as also women. Because women have separate constraints, in our lordships have noticed that in various other issues, because matrimony, etc.
There is no question of going to 41, because 27 now there is 3 fast track promotions are there. There is no question of waiting till 41 and all that. That was probably at the earlier point. Now it is.
Because 50% still go by promotion.
No. Promotions, the fast track.
Promotion part, we are not worried. Promotion part, the avenues have become slightly better.
That your lordship.
No, I'm not saying it hasn't. I'm saying the time gap.
Judgment has dwelt on that in great detail.
Our worry is
My
that
lord.
probably one thing which that might require to be revisited or reconsideration is that should this condition have been applied immediately, or it should have been applied from a date in future. What is happening is today.
We have invested. The students have invested.
16th convocation I have done in
Yes,
couple of months, and it was with a purpose, not that I only invited and went there.
We have 2 submissions.
There are issues which the young, very bright students are raising. Problem is that now, as on date, now you advertise throughout the country, you don't have any young pass out who is eligible to compete. Who are those who have been last 5 years selection processes rejected consistently.
They are eligible to make. Or those who have practiced for 3 years.
This is what I'm saying. Those who have already tried their luck, not selected, but continued in profession, now they have become eligible. Only the competition will now on all India, competition will be confined between them only. The new grad, the bright students coming from NLUs, etc., they are in default now, they are not in a position.
That's right.
It's a balancing between these rights and also what our constitutional high courts also feel should be the correct.
The best of the time.
Absolutely.
With your lordship's permission, may I have two submissions, your lordship?
Talent shouldn't go. They've taken loans, but they've invested in time, prepared. What about the current exams? For example, Bullets, the people who've come out currently or the last year or the year before, Bullets, with the expectation that they'll be giving it for the exams, Bullets, we are turning the rules of the game mid-level, Bullets. And
with your lordship's
round upon by our lordships in every situation.
Lordship.
Bihar has come out to the advertisement.
With your lordship's permission, may I have 2 submissions to make?
Yes, sir.
So do it in phase manner. Say, for example, first it can be 1 year, then 2 years, then 3 years, because by the time classes will start.
So that will be a tweaking of the condition, or that's right. Very, very well.
Lordship, if I may.
Same, how to
balance it out, yes.
apply it, that's all.
So, my lord, may I just, what
One of
your
the
lordship said, give that.
We increase the training in the judicial academies, Bullets, by another year. There's already 1 year provided for. Instead of providing 2 different tiers, Bullets, which is there, Bullets.
No, academy problem in academy, that kind of practical training which you get when you as a junior consul, you go to court.
In internships in college, Bullets, yesterday in our times, Bullets, there was nothing.
Real-time court experience may not be available in the academy.
Because it is mostly.
Sometimes.
The lordship is
But there are other way out. The other way out is that compulsory internship in the offices of the lawyers only.
It is
that for 6 months you do in district court lawyer, 6 months you do with the high court lawyer. That should be part of compulsory curriculum in the law school itself.
That could be done.
That can be.
That is
Lordship,
something
this
that.
clarification that was filed, it was ready.
These things.
My lord, may I just file that submission?
Lordship,
minor clarification.
It was brought in this 1 year compulsory training even before enrollment was brought in 90s, if your lordship would recall. Ultimately, it was set aside on technical grounds of authority, etc. But this 6 months was in district court, 6 months in high courts. In fact, we people didn't have the pleasure of internships. We came straight to the profession and learned the hard way up. The truth is that today's students are having compulsory 12 months. If it could be split up into a logical solution, of practicality, ultimately what has come out in all these high courts is to say this: demeanor, behavior, practical difficulty. That they have to, the training has to come elsewhere also. It will not only be through practice. It's standing in court with due respect.
Some of the high courts have said that
and permission
matters of life and liberty are being dealt with. So high courts have their own views, so I'll put it all across. Just one request, your lordship, to just give us one more opportunity to whichever high court has not filed, which they want to file, and any NLU wants to file, so that holistically everything is before your lordship.
No, this court is probably misnomer. We should have taken the viewpoint of the Chief Justice.
Sorry, my lord?
We should ask for the opinion of the Chief Justice. There is a difference between High Court and...
Very well, my lord, that's very right.
There are issues.
Your lordship.
With your permission, your lordship.
Example, Bihar has come out with the advertisement in 26th of February.
With your lordship permission, we kindly.
What will happen to that in the immediate? That advertisement is already out. When it will be held, I don't know.
With your kind permission, your lordships, we would like to be the petitioner in the 301. We would like to submit to things in the matters, your lordships.
Good category.
That's another category, yes.
There was already a...
So, not there, what happened was that judgment came in the interregnum between this judgment being reserved and this judgment being pronounced. So, the three-judge bench judgment was reserved on 28th of January 25, and before it was pronounced in May, that judgment came. So, none of us addressed your lordships on that issue.
Your lordships.
Otherwise, we would have.
Your lordship, the judgment in 302 anyhow becomes per incurium as per the judgment of this judgment of the 3rd of March, your lordship.
Wait, please.
Your lordship.
Hard-hitting arguments come from later on. We are trying to resolve an issue.
Your lordship, there is a peculiarity in one of the IA. Your lordship, there is a peculiarity in one of the IA, that is 336091. I am a second-year law LLM student of Delhi University, and there the condition has been mentioned that I have to file an affidavit that I am not doing practice, and that affidavit is mandatory for doing the LLM course. Now, your lordship, I have taken admission pre-judgment. 2 years already spent. Now I have to spend 3 more years. That is, I have to spend 5 years. So, lordship, number of states are advertising now, and I will be debarred, your lordship.
There are complications.
Yes.
You please share with it with Mr.
I've got it, my lord. I've got this.
Number of difficulties currently. The law commissions have come out with several reports on this.
So, your lordship, there is a immediate attention is required so far.
Some of the issues which will require some...
Right.
We need to iron out some creases there.
Yes, my lord. I'll make out and circulate it to everybody so that it's not adversarial at all over here.
I mentioned 301.3.
But the most difficult situation is to face the young girls when you go to NLU.
Right.
And because I have been confronted that one.
No, your lordship, sir.
The girls are really, they are shaken.
There is actually a class advantage difference and a gender issue here also involved because of circumstances. And we can't ignore that. The lordship is absolutely right. But in the meantime, while your lordship
the increased percentage, now that we have almost reached 60%,
right,
the women judicial officers. So the girls are our potential material on merit.
Of course not. No one is.
And if they are, because of this condition, the fear is that they will never be able to compete because the families will not allow to go to them.
Yes,
they will be forced to get married and settled here and there. So these are a new type of...
One writ petition is on the ground itself. That's your lordship.
More of the social issues instead of the eligibility issues alone.
No, the idea was, my lord, that whatever ultimately your lordship devise is something holistic so that then it can work for everybody and not that, my lord, every 6 months someone has to come and ask for a modification. So I'll make it in that particular light so that everyone can...
lordship,
we have to improve the quality, there is no doubt about it. And
right.
Practice is a very important component of judicial services. But how to introduce it in such a manner that it does not deprive us from consideration of the meritorious candidates.
I understand.
And it does not create a vacuum of 2-3 years.
And young talent.
Because 3 years vacuum is going to create it.
Yes.
Situation is like this now. that if you go for recruitment today, you do not have any fresh pass out eligible.
The fresh pass out of today not eligible.
So who are the only candidates who have competed already, tried their luck, not selected during last year?
Or those people who did not try their luck but now want to try their luck after having.
Tried their luck, because now those will be trying only, either they didn't try or they tried and failed. Now only they are the eligible candidates.
No, we'll put it before your lordships in that manner so that your lordships can devolve.
Your lordship should also
For
be.
example, Bihar,
Your
in
lordship,
like where they are coming up, something has to be done. It can't go for consideration because they'll be denied outright.
Your lordship should also consider that the process.
It's released its advertisement on 26th of February, Milords, for the exam.
Immediate examinations are there, Your Lordship, and ultimately will not be able to even apply. That's the difficult.
Your Lordship,
Exams are where?
Exams for the competitive examinations now Delhi and Bihar. So immediate requirement is there, 3 years requirement is there. And now I am already barred because of the affidavit condition. I have to spend 5 years now. And at that time, before that, I was eligible because I am already passed out. And I will be losing number of attempts also, Your Lordship. I will be completing my 28 years, up to 32 in a number of states. In majority of the states, the age criteria is maximum 32 years, barring few states like there is 35 years. So if supposingly, Your Lordship, there is a peculiar condition. In 4 years, just 1 or 2 advertisements come in, or one single advertisement is there, I'll getting a one chance only. So getting a chance by a meritorious candidates who are pursuing higher qualification will be discredit to them. They will not be having an ample number of opportunities to appear, Your Lordship. So that is an absolute peculiarity which has come up.
This actually might be a Delhi specific.
Delhi is specific, and we are the
Only
meritorious.
Delhi University is saying that for LLM course you can't practice.
Yes.
Our Council of India has said that while you're doing an LLM you can practice. But Delhi University, so this is not an all India problem that my learned friend has. It is a Delhi specific problem.
And Your Lordship, there is a judgment to that effect also. Honorable Division Bench of Delhi High Court has already categorically held that Resolution 96 of the Bar Council of India that permits that LLM is not a bar at all. So the Delhi University's curriculum, their rules and regulations and their resolutions are contrary to the resolution passed by the Bar Council of India.
You have to address that before the High Court.
He has approached the High Court.
I approached the High Court, and Honorable High Court said, all right, this remedy is not available to us. So that's why I take a liberty that in the meantime I'll approach the Honorable Supreme Court. So they're not considering, Your Lordship, frankly speaking, we have to withdraw the petition from there.
Vacancies Bihar.
Lordships, we just
Advertisement.
request for.
173 vacancies, Bihar has come out with the advertisement below on 20.
Lordship
Your Lordships, we are.
also has to consider the process in itself.
In the opening, we'll keep it. And,
Very well.
With the Lordship's permission.
I'm sorry, my lord.
uh,
We'll do it in the next week whenever your lordship after that wants, whichever convenient. Lordship do it.
Lordship, there's this IA position.
Your Lordship, I am seeking to mention 301.3. Your Lordship, this is wrongly tagged because the 301.3 issue is different, Your Lordship. 301.3, that is a writ petition, and 3rd February it was listed, Your Lordship, directed to me to amend the petition. I have made all state bar councils party. There is a, Your Lordship, issue is registration of the advocates. Therefore, Your Lordship, this matter will maybe be de-tagged, Your Lordship.
Bar Council. Madam, why you are taking 6 months in issuing registration?
Your Lordship, I will, he may supply a copy to me. It cannot be 6 months. I will have it.
Get the instructions.
I will get it.
Clear that once a candidate apply, and if you fail to grant him license in 3 months, then he will be deemed to have been authorized.
Your Lordship, it will not be 6 months. I will check. A copy will be supplied to me, Your Lordship.
My self-registration taken 6 months, more than 6 months.
No, Bar Council.
It would be the
Uttar
state
Pradesh,
bar
Your
council.
Lordship, Bar Council of Uttar Pradesh.
But I will find out from.
Bar Council of Uttar Pradesh, my Lord.
Bar Council.
See, I'll find out from the state.
You have to issue a policy circular from your side that every state bar council will ensure that within 3 months maximum.
Then your
inquiry, etc. is to be done. It must be done, and within 3 months the license must be issued. Otherwise, we will pass a judicial order that they will be deemed to be eligible for the purpose of.
I'm sure there's already a policy, Your Lordship. I'll place it. I'll just take the papers.
Your Lordship,
may I mention an IA?
humble
It was
request,
ready
my
for
Lord,
listing in
this
October.
may be de-tagged, Your Lordship. Because issue is different, Your Lordship. My request is de-tag this matter.
It is
tag or tag, we will do. On that day you got it tag, now you should be tag.
No, Your Lordship. I have not requested, Your Lordship. for the tagging.
Your item.
Tagging 301.3, Your Lordship.
Before the regular bench.
Please.
Lord, we have two things.
May I, my lord, mention a matter to be put along with this batch filed last year? In July last.
Similarly, Lordship, there's another IA. It was ready for listing in October last year. It has still not come up on the.
So like, give us the particulars, we'll see.
Your Lordships,
Take up on the opening week, so.
Lordship,
in the meantime, if your lordship just don't mind saying that let whichever High Court still wants to file Chief Justice, they can do it so that it's all covered.
In reference to the ethics one, so some of the High Courts have, most of the High Courts have sent their opinion.
With your Lordship's permission.
Madam,
With your Lordship's permission.
Highlighted one.
With the Lordship's permission, we just have two things to Lordship's submit.
The discharge journals of the remaining High Courts, of the left of High Courts, giving last opportunity to submit their viewpoint by 9th March 2026. Post this matter on so date after 1 or 2 days at 2 p.m.
Lordship, may kindly
Lordships, we have two submissions to make.
notice in the modification application.
Lordships, we have two things to mention.